Honorable Singh, you are here. Honorable Mdise, you are here.
I'm here. Good morning, President.
Good morning, Deputy Minister Sochu.
Morning, Chair, and morning to all members.
I'm trying to check the other members. Honorable Mtunu was trying to log in. She seemed to have had a different login details.
Morning, Chair. I found the details now. I'm in.
You are in.
I'm now in, Chair.
Okay.
Thank you.
We have an apology. Honorable Bright, good morning.
Good morning, Chairperson.
And welcome. Okay, I think we need to start our meeting. I want to first welcome all our guests that are in our midst, especially our presenter. I'd like to welcome the Presidential Climate Change Commission team led by Dr. Olva. Welcome. As and when you do the presentation, I'm going to introduce the delegation. Same thing with the Center for Environmental Rights. Mr. Abidno, you'll do the same. Professor Miller from Veld School of Governance, you'll do the same. The team from Amabungane, led by Ms. Comrie, you'll do the same. And the South African Human Rights Commission, led by Ms. Ramison, I think you'll do the same. Kosato, I see you are on your own. Mr. Pax, welcome to the meeting. I also want to welcome all the interested parties who are in our meeting. Having said that, can we ask our secretary to fly the agenda so that you both see, but I believe it was sent to all of you. This is how we are going to proceed. This is how we're going to proceed. And I want to apologize. Our committee meetings normally start at 9:30. I missed that time of 8:30 today. I don't know what happened. In my mind, I was thinking we were starting at 9:30. I want to apologize for keeping you wait, but we'll make up on the time lost. We are going to proceed as it is. From the colleagues, can I ask the mover and the seconder of this agenda so that we can adopt it?
I move, Chairperson.
Honorable Bright, supported by Honorable Mkunu. I suppose you are supporting Honorable Mkunu?
Yes, Honorable Chair.
Thank you so much. Thank you so much. Then the agenda is as adopted. I want to welcome all of you to this meeting. When we do that, I just want to highlight the following. I think the reason all of us are here today, we all agree that climate change is transforming our lives in some alarming and unimaginable ways. You talk about drought, heat waves, erosive rains, and the recent catastrophic floods that happen in KZN. And when you look at all these things, definitely they are climate-induced. And it affects all of us as South Africans. You could not possibly see those pictures and the devastation without a deep sense of pain and compassion arising from within you. Climate change is making livelihoods, resources scarcer, weather, water, arable land, food or energy, and this could lead to a breakdown in established codes of conduct, even to outright conflict amongst those who have lived side by side for years. Our increasingly unstable climate is no longer seen as primarily an environment or economic issue, as our climate has evolved in the recent past to a larger threat and sharper in outline. As we start to engage today, we must therefore focus more clearly on the benefits of early action, which for us as South Africans is long overdue. This is why the climate change bill before us recognizes in its preamble that climate change will contribute, I quote, increased frequency and intensity of extreme weather events, will affect, amongst other things, human health, access to food and water, biodiversity, habitats and ecosystem, the coast and coastal infrastructure, including human settlements. As for you, my colleagues, you'll recall that we have implemented climate action using a myriad of tools that sit in different government departments, with the Department of Forestry, Fisheries and Environment coordinating these various climate actions. This approach, colleagues, has increasingly been inefficient. Therefore, in this regard, that our government thought it would be wise to initiate the process of formulating a law, especially dedicated to climate change. The bill before us shows our unwavering commitment to make a fair contribution to stabilizing the global GHG concentration in the atmosphere and to protecting the country and its people from unavoidable impacts of climate change. We know that this bill has been long in coming, first mooted in the 2015-16 financial year, according to our records. We are now at the stage of holding our first meeting on the bill here in Parliament by asking the 6 of our stakeholders present here today who had made submission on the bill to make oral presentation on their submission to this committee. And then I should think it will be important to note that 13,200 submissions were received from individuals and organizations in response to our advert soliciting inputs from South Africans on the climate change bill. Although thus far we don't know the details of all of those submissions, we have good reasons to believe that there are useful inputs among them based on what is before us this morning. And I will therefore want to welcome all of you in the meeting. And then, having said that, I will then hand over to the Presidential Climate Change Commission. Mr. Oliver, you have 30 minutes with your team, and I will prefer you first introduce them if possible. Let's see their faces, and you can then proceed. Over to you, Dr. Oliver.
Thank you, Honourable Chairperson, and very good morning, Honourable Members and Deputy Minister Sotu. It's a real pleasure to be appearing in front of you this morning. And there are some familiar faces who I know from long ago when I was DG of the department. So it's really good to see you. Just to introduce the team that's with me. So my name is Crispian Oliver. I'm the Executive Director, which means I basically run the Secretariat for the Commission. And I'm joined by Dr. Thuli Khumalo, who is our Chief Operations Officer, by Mr. Blessing Manali, who's the Head of our Communications and Outreach, and Mr. Deepak Patel, who's the Head of our Climate Finance Division. I don't know if they could just put their cameras on briefly as the chair requested, so we can see.
Cheleka, can you remove the agenda on the screen, please? There we go. Dr. Kumalo, where are you?
Now wondering whether she's actually joined. I did see her joining earlier, but she may have connection problems. Mr. Manali, can you just show us your face? There we are.
It should be showing Executive Director.
We can see
Yes.
that.
And Mr. Patel. Oh, there we have Dr. Kumalo. Welcome.
Oh, am I the she that you were just talking about?
Yes. The chair wanted to see you physically so that we know you're a real person.
I am real, Chair. Good morning.
And at some point, Dr. Oliver, you must explain to us why you posed there.
You know, the thing is, we were looking for the best, Chair. And Dr. Kumalo is the best of the best. So we're very proud to have her. As I explained to Minister Creasy, who complained that I was poaching her staff, I said that the Commission is going to assist DFFE with its work. So it's not as if she was being lost to the DFFE system. Chair, I'm going to take you through a
Chairperson.
I think you've omitted Mr. Naidu. Where is he? Then you'll come in.
Mr. Patel. He's hiding away from us, Chair. I'm now wondering whether he has joined. I'm scrolling down the list. I don't see him in the meeting. Maybe he's had connection issues. So apologies.
Okay, can I first listen to Honorable Singh? I thought it was in historical end. Honorable Singh.
No, Chairperson, thank you very much. Sorry to disturb you, Dr. Oliver. We go back a long way with many of them there. I just wanted him, while he's giving us his presentation, to tell us whether the Commission has had any input into the draft bill that's before us as presented by the Executive. Or you haven't had any input into it and now you want to make an input to the Portfolio Committee. If you could clarify the role of the Commission vis-a-vis the Executive and the Committee.
Yeah.
Thank you, Chair.
Okay.
Chair, yeah, I can do that as I present. But just to clarify, Chair, the Commission was, formally established in December 2020. We only really got underway the following year, 2021. As you indicated in your introduction, the climate bills had a long genesis. I mean, it had been through public consultations, it went through the NEDLAC process, it had been through various rounds of discussion in government. So we basically arrived as the climate bill was in its final stages of being put together. So no, we didn't have any direct input into its process at that stage, but obviously we have had sight of the bill as the Commission, and the Commission has discussed it. And we made a formal submission with the Commission's mandate. And we discussed further on Friday this meeting and received further input. So in a sense, we're meeting this bill really for the first time in this process in terms of our inputs. I trust that clarifies it, Honourable Singh. But we can come back
to it. Thank you.
Yeah. So, Chair, we put this presentation together. It looks at the ball in a comprehensive way. And our submission was a little bit more specific. So we focused really in the written submission just on the provisions that relate to the Climate Commission and its establishment. But I've taken the liberty in this presentation of making some broader framing comments, if you don't mind. And the starting point is our concern about the risk that we face as a country, and in particular the risk to our development as a nation. And there are two kinds of risks that we face. The one is our vulnerability to what we call transition risk. And that's because we are one of the most carbon intensive economies in the world. If you look at carbon intensity per GDP output, or the carbon intensity basically of the products that we produce and we export, we are the single highest in the world. We've got a carbon intensity that is almost double that of China's, and it's 75% higher than that of India's. And as the world starts to decarbonize and implement measures to, cut carbon emissions, inject a price into the global economy, our economy stands particularly vulnerable to those risks. And if any kind of international trade restrictions come into operation, it's going to affect us very severely. The other risk we face is a physical risk. And, you are, as this committee, I know, well familiar with the physical risk that we face as a country in terms of warming, extreme weather events, floods, rainfall patterns, the effect on droughts, the way that cascades into our food security as a country and our water security. And, I've just put one diagram up there. I mean, this is from the latest IPCC report, the Working Group 2 report. This is just looking at the anticipated change to rainfall patterns at different levels of global warming. And, we're on track at least for a 1.5 degree warming, probably 2 degrees if you look at the current pace. And you can see that under all of the scenarios, we're going to be drier, particularly on the western parts of the country, but really across the whole country. So I'll come back to this later, but I just wanted to bring out these sort of two risks that we have to navigate as a country. And those are laid on top of our development context. And, just to be brief and blunt, extreme levels of poverty. I mean, more than half of our people live in poverty, untenable levels of unemployment, with youth unemployment, almost 2/3 of young people being unemployed. We're the single most unequal country in the world. We've got a weak economy, we've got a weak skills environment. We're very carbon intensive and we face major trade risks going forward. And we've got very challenging spatial distribution. So, we still essentially are replicating the apartheid spatial form of our cities, which is very inefficient and very carbon intensive, as well as this urban-rural divide that we have. Now, as the Commission, we've been in operation for 1.5 years. We've made 2 major recommendations. The first was on what's known as the country's nationally determined contribution, which is basically, the emissions trajectory out to 2030 that we're going to be following. And you'll recall, Chair, I think you were briefed on this more fully by the department. We recommended a slightly more ambitious NDC, which took us on a steady path to net zero emissions by around mid-century. And the reason for that is that it's in our economic interests to be proactive about this, as I've indicated earlier. And then the second major framework we've recommended, which has just been approved by Cabinet, we're very pleased with it, is a framework for a just transition in South Africa, which is really about how we're going to make sure no one is left behind in this transition, and that we specifically ensure that every worker has a transition plan, and that we actively support workers and communities affected by this transition to enable them to adjust. There are two critical things that we need to do as the country. One is to show leadership, and the strategy that we need to pursue, a strategy of delaying, denying, trying to not adjust, pretending we don't have a problem, is simply going to lead us into an economically very inefficient and undesirable outcome. So we argue that we need to hold other countries to account, and to lead in the space, also to demonstrate a requisite level of ambition. Obviously requisite with our own development needs and priorities. And the second is about making sure that climate and development are intimately linked. And what's become increasingly clear over the last few years is that climate is no longer just an environmental issue. I mean, it obviously is a very important environmental issue, but really it cuts to the heart of our development challenges as a country. And we need to put our people and their interests, their development at the heart of our decision-making about this transition. So come to the bill. The bill basically needs to provide the institutional and the regulatory basis to put us on this pathway. And, we believe that it substantively does. And we applaud the fact that it's now in Parliament and that you're conducting these public hearings. It's very significant. We want to just make a few points about the bill. So, firstly, we support the objects that are set out in the bill. We think they're well phrased. We want to recommend, in line with existing government policy, that you include a target of achieving net zero CO2 emissions by around mid-century in a socially just and economically sustainable manner. So that's an objective that's in our low emissions development strategy. We submitted it to the UNFCCC a few years ago, and it's in the recently adopted Just Transition Framework. And it's important to understand where we're headed so we can make decisions now about the key things we want to achieve. Secondly, Chair, we think the principles that are articulated in the bill are excellent. We've got no real quibbles with them. I've included in red a few suggested additions. So in terms of the just transition part, we think in addition to decent work for all, social inclusion, eradication of poverty, we should explicitly refer to the reduction of inequality. With respect to the risk-averse and cautious approach, we recommend including the risk of not acting timeously. So yes, we need to be cautious about our existing amounts of knowledge, but we also should not delay action in a way that puts us behind the curve as the world starts to transition. And then lastly, with respect to costs being paid for those responsible for causing the problem, principally the developed countries in the north, we think there should be specific reference made to loss and damage, which links this legislation very clearly to an active discussion that's going on at the level of the UNFCCC. It's going to be the big issue that's under debate at COP27 at the end of this year. In terms of the institutional arrangements, Chair, so the bill establishes a number of mechanisms. So this is the chapter that gives effect to the Presidential Climate Commission. As you know, it's a multi-stakeholder body. So we've got organized labor, organized business, civil society, academics, young people, and a whole range of government ministers, mainly from the economic cluster. So we'll come to the Presidential Climate Commission, and then there are recommendations around intergovernmental coordination, which is basically using the existing system of the President's Coordinating Council, the Premier's Intergovernmental Forum, and the District Intergovernmental Forums, and it makes those also function as forums on climate change, and it empowers them to set up intergovernmental technical support structures. So just a few comments on the Chapter 2 proposal. Firstly, Chair, we think the provisions for the involvement of social partners should be strengthened. So, you've got the social partners sitting in the Climate Commission at a national level. Our recommendation is that you amend 7.2 to state that organized labor, civil society and business must be involved in decision-making on the country's climate response, and their views must be taken into account before decisions are made. So this talks directly to the principle of procedural justice. Secondly, Chair, with respect to the intergovernmental coordination forums, I know that the bill is really going for these statutory intergovernmental coordination requirements. We suggest that you consider including some enabling provisions that add incentives and possibly a link to budgetary mechanisms that would incentivize and promote greater coordination. And then lastly, Chair, we recommend that social partners are involved in climate decision-making at all levels, so not just nationally. And we would like the bill to explicitly refer, possibly as an enabling provision, to multi-stakeholder advisory or social compacting bodies at provincial and local level. Just briefly, with respect to the Climate Commission, we believe that the bill should strengthen the provisions for its independence and impartiality. Our suggestion is that Parliament should be involved in the process of selecting and recommending commissioners. That will give it a far stronger status in terms of its integrity. Secondly, we believe that you should ensure its independence through its establishment as a separate statutory body with its own administration. It shouldn't be run by a government department, and that the Commission should report to Parliament on its work and finances. This should be the body to which we account. Just with respect to the functions that the Commission performs, these are captured in part. We would like to emphasize 3 points. The first is that the Commission must provide advice based on the best available science. So you're wanting this Commission not just to give you its opinions, but to go out there and find what the latest science says and provide it to decision makers in a frank and undiluted way. Secondly, we suggest that it's mandated to build consensus between social partners. So it needs to play a social compacting role. And then in addition to the mitigation and adaptation areas that are included, we suggest that the Commission's explicitly requested to advise on the just transition and on means of implementation, basically on climate finance and the technology and investment that you need for the Commission. With respect to the Chapter 3 provisions, so this is where it talks about the role of provinces and municipalities, and it explicitly requires the MEC and Mayor to undertake a climate change needs and response assessment, and then within 2 years to develop what's called the Climate Change Response Implementation Plan. It's a little bit of a complicated word. And this is done for district and metropolitan municipalities. And the trigger for those two in the Act is the publication of the National Adaptation Plan. We've got a few recommendations on that, Chair. So firstly, just to note that cities are already developing what they call climate action plans. And these are really, I'm sure Selga and local government will present further on this. These, some of these are really great dynamic plans. And we prefer that title to this rather wordy Climate Change Response Implementation Plan. We think it gives a more dynamic interpretation, and we'd suggest that the provisions of the bill are aligned better with what local governments already do. Secondly, we suggest the provisions are extended to include all municipalities. In other words, local municipalities as well as district and metropolitan municipalities. And then lastly, just to state, this is not just about adaptation. So adaptation is a very important part of it. But you're wanting these structures to do an integrated response, which should include mitigation and just transition. And you're aware of this, I'm sure, but it bears emphasis that municipalities have a very important mitigation role to play through, for instance, their electricity distribution, waste management, public transport, and land use planning. On Chapter 4, which deals with adaptation, it's a really excellent chapter, very strong, sets out adaptation objectives. It requires the department to develop adaptation scenarios and the national adaptation strategy and plan, and then for sector departments to develop sector adaptation strategies and plans. So all of that's excellent here. 3 points on adaptation. Firstly, we suggest you create a link to a disaster risk financing mechanism. I know this might be a money bill matter, so you may need some legal advice on that. Secondly, on loss and damage, I mean, this is a fundamental issue. We'd like to propose the establishment of a loss and damage mechanism funded through compensation and the obligations of international and local polluters. And then lastly on this section, Chair, the sector plans. It's important to note that all these different sectoral departments need to do mitigation, adaptation, and just transition. So our suggestion, instead of getting them to go off and do separate adaptation and mitigation plans, we simply ask for sector climate response strategies and plans. So you integrate all of that, and line departments only have to produce one plan. On the mitigation side, I'm not going to dwell on this. It's very well set out in the bill, and it talks to our emissions trajectory, the greenhouse gas emissions inventory and the listed gases, and it provides for the setting of sectoral emission targets and carbon budgets, and the phasing down of synthetic greenhouse gas emissions, all excellent provisions. Our suggestion is that there's explicit reference made to the Paris Agreement, which is really the starting point for our policy on this area. We also want to emphasize that the national carbon budget, we talk a lot about the emissions trajectory, which is, a course that emissions will follow over time. The key issue in climate mitigation is the carbon budget. So what is our overall national budget as a country? Is it 7 gigatons, which is what, 7 to 8 gigatons, which is what is in line with our fair share? Are we going to overshoot it and maybe look at a 10, 11, even 12 gigaton budget? This is a very active debate. So we believe the bill should establish a rolling 5-year national carbon budget as the principal tool to guide mitigation measures and to then inform all these sectoral and company level budgets. The carbon budget system is going to be hard to implement. I mean, to ultimately cascade this down to individual company level budgets takes an enormous amount of work and negotiations, and it needs to be done very carefully, otherwise you're going to cause economic chaos. So what we believe the bill should do is allow for the progressive evolution of this carbon budgeting system over time, being aware that we may require increasingly stringent measures in the future. So you want to, in a sense, create a toolbox of measures. You want to align this with the carbon tax, which is what Treasury is implementing, and look at adding into the regulatory toolbox incentives to innovate and to mitigate beyond the budgets that are set. And then just to note, Chair, that Schedule 3 is not aligned with the current NDC. We suggest it's updated, and that further updates are automatically linked to the NDC updates that we submit as a country. On M&E, Chair, I won't dwell on this. We love the focus on M&E in the bill. We've made some specific recommendations about how that could be tightened up and supported. And in closing, this is my last slide, Chair, just to state that climate change poses serious long-term threats to our development as a country, and it threatens to roll back many of our development gains. But there are also opportunities for our industrial development and our economic transformation if we're proactive. And this bill is an extremely important measure to integrate climate into the decisions of government and also into the decision-making of all the social partners. And you're busy with a fundamentally important piece of legislation. It's going to lay the foundations for our just transition to a net zero economy and a climate resilient society. And as the Commission, we stand ready to support in terms of whatever science-based advice and engagement with social partners that you deem fit. Thank you very much, Chair. That concludes the presentation.
Thank you so much, Dr. Olver, for a detailed representation. I should think we'll deliberate in line with our program, and let's allow the Center for Environmental Rights / Life After Code to present. Mr. Abidno, over to you.
Thank you, Chairperson. Good morning. Good morning, honourable members, Deputy Chair. I'm joined by Deputy Director Wandisa Palmer, and I'm going to hand over to her first. Thank you.
Are you only two?
That's right. Yeah.
It's only the
two of us.
I've already seen a smiling red. Over to you, Alice.
Good morning, Chair. Good morning, honorable members. As introduced, my name is Wandisa Palmer, and I am the Deputy Director of the Center for Environmental Rights. And I am doing this presentation with my colleague, Brendan Abdullah. Chair, firstly, we are grateful and relieved to see the bill progressing towards being our all-important Climate Change Act. And we trust that this process will continue in a constructive and prompt manner. We have no time to waste addressing the climate crisis that is already impacting us. And this piece of legislation will empower us to mount the effective climate change response required to literally save lives, infrastructure, and the economy. The risk of climate change impacts are by now hopefully well known. Far from being an abstract issue of climate alone, climate change for us in South Africa will mean tangible disruptions such as rising food prices, restricted water access, rising unemployment as businesses can no longer function, climate migration, social instability, and the potential for internal conflict and violence. In short, climate change is first and foremost a human rights issue. Put differently, a climate change crisis is a human rights crisis. Conversely, a well-managed climate change response can lead to widespread socio-economic well-being as we embrace a low-carbon, green economy and upgrade and improve living conditions for millions. To achieve this, we need an effective Climate Change Act. As much as we need to see this act come into being as soon as possible, we also need to see certain limitations and deficiencies in the current bill before you being addressed. As the committee would be aware, we made comprehensive comments on the bill in May of this year. These comments arise out of extensive research, consultations, and have been endorsed by bodies such as the Human Rights Commission, Section 27, the Center for Child Law, the City of Cape Town, and others. We urge you to take the full range of our comments into account, but we will use this opportunity today to highlight key concerns and recommendations that we have on the bill. I will talk the committee through the first 4 issues we wanted to raise, and my colleague Brandon will come in for the rest. Expanding on a little human rights aspect, a court in Brazil this year held that adherence to the Paris Agreement is a human rights issue, and that the agreement takes precedence over domestic laws. Also this year, the Philippines Human Rights Commission held that the conduct of 47 major green gas emitters was immoral and may lay a basis for liability for human rights abuse. We can expect to see these trends growing. This year, the United Nations Framework Convention on Climate Change released a report on the gender-differentiated impacts of climate change. The report paints a grim picture of how women are already facing significantly elevated risks of climate harm. The research also confirmed that climate change exacerbates many patriarchal dynamics in society, including systemic gender discrimination. There are many documented cases of gender-based violence being exacerbated in the wake of climate-induced disasters, such as cyclones and floods. Around the world and here in South Africa, women and girls are the household members most often kids are expected to perform chores such as fetching water and firewood. As climate impacts steadily increase, so too do the distances that girls need to travel to find these resources. This also increases their vulnerability to experiencing gender-based violence. Women in rural parts of South Africa are also most likely to be responsible for maintaining food gardens as a means to provide food for their families. Climate impacts such as floods and droughts also negatively affect this essential form of subsistence farming. We highlight these issues, honorable members, to show that when you balance the comments from various sectors, including high emission sectors, who may resist a strong climate change act or strong climate change action, that we're not talking about balancing against some vague and far-off seeming environmental needs. We're really talking about the survival needs of people. On the issue of public participation, given the extensive nature, given the extent and the nature of climate change crisis and the far-reaching impacts on all levels of society and regions in South Africa, we strongly encourage a highly comprehensive program of meaningful public participation. Our experience has shown that geographically remote and economically distressed communities and individuals are often effectively excluded from meaningful participation, both online and in person, in processes of this nature. This is often due to prohibitive data and transport costs. Additionally, much of the information presented and issues to be considered are couched in technical language, which effectively excludes full and meaningful participation. To circumvent this challenge, we recommend that the following be considered. In-person hearings in all regions and all large metros. Particular focus should be given to key areas strongly affected by the climate change response and the just transition considerations. For example, Emalahleni, Lephalale, Newcastle, areas where a majority of South Africa coal power plants and mines are based. And in Lephalale's case are also water scarce and highly vulnerable to climate change impacts. The second recommendation on this public participation point is we ask that there be knowledgeable translation and interpreting services in these public hearings. Adequate and effective notice of hearings is a must going forward in this process. Information that is relevant for meaningful participation in the hearings must be given to people in advance in a manner that is accessible for them to understand in order to prepare for the hearings. Invitations to comments and other participation processes should also be provided. Given that certain sectors of society, particularly women and youth, are shown to have to carry a disproportionate burden of the climate crisis impacts, we recommend that additional measures be taken to ensure their adequate consultation and adequate proportionate representation of youth and women throughout this process. Related to the public participation points, we understand that there are also a number of other civil society organizations like us and groups who have made substantive comments on the bill itself, who do not appear to have been invited to make oral submissions at this stage. And we ask the committee to perhaps clarify the criteria that was followed to invite some of us who are in the room to make these comments, and whether there will be public hearing processes that are to follow and when these will be taking place. The third issue that I would like to address is around agency and timeframes. Honorable members, the floods in KZN in April of this year, the day zero drought in Cape Town have scientifically been linked to climate change. It is here now, and the urgency to respond is high, as are the costs. We are advised that the Ministry and the Department of Forestry, Fisheries and Environment are undertaking many activities envisaged by the bill. but this is done on a voluntary basis and dependent on voluntary goodwill of other ministries and private sector employment and private sector role players. We cannot rely on this goodwill and need long-term legal certainty and clear statutory backing for a number of key mechanisms that currently have no deadlines or timeframes in the bill. In terms of mitigation, the bill unnecessarily relies heavily on certain mechanisms to provide certainty and enforceability for key mitigation action, most notably the allocation of carbon budgets. These are assigned. These are an assigned amount of greenhouse gas emissions allocated to a person by the minister, as well as the determination of sectoral emission targets. Greenhouse gas emissions limits are to be allocated per sector. Neither of these key mechanisms in the bill have timeframes or deadlines attached to them, creating the real and perceived risk that the Climate Change Act in this aspect may be toothless and ineffective. In terms of adaptation, the bill prescribes various steps to be taken by national, provincial, local, and local government to assess climate change needs and then produce response plans. In the case of provincial and local government, the obligation to produce a climate change response implementation plan only becomes mandatory a full 5 years after the Climate Change Act has come into operation. We consider the nature of, when we consider the nature of the potential near-term climate change impacts in South Africa, we can see the need to mainstream climate change adaptation in the relevant organs of state is critically urgent. The last issue I will address before the committee, before I hand over to Brandon, is on transparency, access to information, and proactive disclosures. When it comes to climate change, the most serious global challenge of our time, complete transparency and automatic disclosure of information must be the default position. And any deviation from this position should be justified publicly by those wishing to do so. In its current form, the bill provides for inappropriately limited access to information. Because the climate crisis impacts on every person, community, business, and social activity, and people need information in order to understand how the country's climate response is progressing, what their risks of exposure might be, and how the different role players are responding in terms of executing their mandates and responsibilities. Transparency is a critical measure of holding greenhouse gas emitters accountable, particularly given our own limited compliance monitoring capabilities. Transparency enables action by civil society to call for enforcement of environmental laws as envisaged by the preamble to NEMA. The bill provides that any information that is provided to the minister or the department must be made available to the public subject to the Promotion of Access to Information Act, PI, and the Protection of Personal Information Act, POPIA. This provision in the bill is weak and unacceptable. In both PI and POPIA provides grounds, in that both PI and POPIA provides grounds on which providing information can be refused, for example, on commercial grounds. While we understand personal details like names, phone numbers, and addresses may be withheld, but POPIA cannot be used as an excuse to withhold greenhouse gas emissions data, for instance. It is imperative that the bill provides automatic disclosures of information that is critical to climate change mitigation and to enable people to prepare for and adapt to climate change impacts. The wording of the applicable clause in the bill also suggests that information generated by the minister or the department, which could include important information relating to the response plans and activities, including monitoring and evaluation, does not need to be made publicly available. The bill should make express provision for data and reports generated under provisions of the bill to be gazetted and also made available online and automatically on request. The Minister herself has acknowledged in a prior appeal decision on the disclosure of greenhouse gas emissions data that, I quote, "The overall purpose of administration of justice requires the disclosure of an anticipated projected emissions and the data relating to anticipated and actual emissions," close quotes. There is therefore no reason why on greenhouse gas emissions, anticipated emissions, and emission reports by emitting facilities should not be made automatically available as a default position. Our experience has shown that given the limited compliance monitoring capacity within government, civil society and non-governmental stakeholders are often compelled to monitor and raise awareness on social and environmental harms such as pollution. Climate risk assessments and adaptation plans and strategies can profoundly affect people, communities, businesses that they are intended to protect. Sound adaptation will in cases mean changes to infrastructure, human settlements, provision of essential services, spatial development, transport, and the commercial and social landscape. It is therefore essential that that the latest and evolving assessments and plans are easily publicly available so that people, communities, businesses can make appropriate choices and plans in response to intended and actual adaptation actions taken by state actors. Additionally, the very individuals and groupings who are supposedly being protected often have important experiences and knowledge about adaptation needs and need to have access to this information in order to meaningfully contribute to the assessment and risk management activities. We recommend that the bill provides for a publicly accessible web-based information portal that provides regularly updated and well-structured and easy to understand data and information on all key aspects of climate response, including but not limited to the items referred above. This information should also be translated into relevant official languages for easy access. I will now hand over to Brendan McCulloch to talk through ambitious, clear and effective emissions targets that we are asking for in terms of the Act.
Thanks, Vandisa. In terms of targets, the urgent need to curb emissions along with clear target and strict emissions trajectory are not adequately set out in the bill, in our opinion. And the new legislation cannot be effective unless there's absolute certainty on what the goal is. And we feel that the bill must make explicit reference to the Paris Agreement targets of holding global warming to well below 2 degrees. And making every effort to limit it to 1.5 degrees. And to do that, we think the bill should explicitly and immediately set out a strict trajectory that reflects at a very minimum the current NDC, and we are of the opinion that the lower range of the NDC is indeed the one that should be provided for. along with an express and urgent requirement for further downward ratcheting. In other words, we can make adjustments downwards, but they cannot slide back up. We also think that the bill should stipulate long-term and interim targets. We know from the IPCC that in order to achieve the 1.5 degree warming limit, along with other nations, we need to reduce emissions by 45% by 2030 over 2010 levels, and aim for net zero by 2050. In terms of net zero, we do have a concern around that as a notion, as a target, in that it relies on future uncertain technology or inappropriate or inadequate nature-based solutions to actually remove CO2, or as much CO2 as is being emitted from the atmosphere. And we can already see how this notion grants emitters a kind of false license to delay real and meaningful emissions. And this is particularly concerning for sectors such as electricity, where low emissions alternatives such as cleaner and renewable energy generation are in fact already readily available. From what we can see, neither technology nor nature-based solutions are even remotely likely to come anywhere near being able to counter the level of greenhouse gases that we are emitting at this point in time. And on this basis, we suggest that instead of using the concept of net zero, we should be putting near zero or absolute zero into the bill. By putting a target of near zero in, it allows a little bit of space for those really hard to abate sectors to have a little bit of space to be able to continue, and that can perhaps be offset by future technologies around carbon capture and that kind of thing. Also, given the urgency of the emissions reduction, so again, that 45% by 2030, which is now less than 8 years away, we suggest that the bill should contain or at least cater for interim emissions reductions targets, which will help to ensure immediate action and not a situation where we're deferring mitigation action to some distant point in future. And from that point of view, we suggest that at the very least, the bill should prescribe that the minister establishes within 6 months or at most a year adequate interim targets, at the least for 2030 and 2035 towards this goal of near zero by 2050. Another aspect that is of quite serious concern for us is this issues of penalties for non-compliance. Obviously, one of the biggest imperatives of the bill is to ensure adequate emissions reductions. But we're not seeing that coming through in terms of the penalties and compliance terms in the bill as currently stood. The only criminal offense in the bill at this point in time is the failure to submit a greenhouse gas mitigation plan to the minister. But there are no penalties for failing to implement a plan like that or for failing to report, monitor, or effect remedial action. If the plan is not being adhered to or a carbon budget is being exceeded, there are no serious consequences for these failures. And this leads us to the risk that the bill is effectively relatively toothless in terms of being able to ensure emissions reduction. And of utmost concern is that there's no penalty, criminal or administrative penalty for exceeding a carbon budget. And the carbon budget is the clearest and strongest mechanism in the bill for ensuring emission reductions. We do know from statements by the Minister of the Environment as well as National Treasury that a higher carbon tax rate is intended to be levied on emissions exceeding the carbon budget. But we think that this is highly inadequate as being the sole mechanism for ensuring reductions. Particularly in the case where the carbon tax might not be high enough to actually disincentivize violations, and companies could effectively be in a position where they choose to pay perhaps a moderately higher tax rate and continue with greenhouse gas emissions. So we would also like to see a broader range of penalties, including the revoking of the license to operate where emitters regularly exceed carbon budgets or fail to adhere to mitigation plans. Why we are calling for administrative penalties is the fact that criminal sanctions are very time consuming, complicated, and consume resources. And administrative penalties avoid many of the main constraints of criminal enforcement, including the burden of proof and the time and complexity inherent in securing a criminal conviction. In terms of capacitating and empowering organs of state, the bill places a large burden on municipalities, provinces, other sector departments, and the minister without making adequate provision for capacity building and funding. Financial support, technology development, skills transfer, and capacity building are key aspects in the Paris Agreement, yet these issues appear to be absent from the bill. It is unclear how many of the municipalities in the country, provinces, and sector departments, which are already struggling to fulfill obligations in relation to air quality, water, and waste management, for example, will have the necessary capacity and resources to carry out the obligations in the bill. In terms of mainstreaming climate response across government, we feel that the bill does not adequately provide for a strong and suitably prioritized climate response across government as a whole. Climate change cannot be relegated to being an issue that needs to compete with all of the other issues facing government, potentially leaving the minister and the department to struggle for cooperation and compliance with the provisions of the bill. So we've come up with some recommendations that the bill should include in order to ensure this kind of all of government or mainstream approach. For example, establishing an executive, non-political interdepartmental body to oversee cross-sectoral implementation, compelling the minister to report to Parliament, ensuring that the national budget is directly, excuse me just a sec, please, that the national budget explicitly needs to deal with climate change response, strengthening the powers of the minister to issue guidelines and receive reports, and then creating what's taking place in some jurisdictions around the world, creating focal points, so dedicated people within different ministries who will deal with climate change response, ensuring that climate change considerations in state procurement policies are stipulated, and that key instruments such as the integrated resource plan be formulated and used to support the necessary emissions reductions pathways. The bill also fails to stipulate clear guiding principles for decision-making under the bill and does not directly provide for assessments of climate change impacts across all decision-making within and by organs of state. We feel that the consideration of climate impacts need to be applicable in all state decision-making about any matter that is impacted by climate change or potentially contributes to climate change. The public participation process in the bill only applies to a range of instances, but not in certain key instances such as the making of regulations or certain of the regulations or any of the provisions relating to carbon budgets. The public participation process needs to make more provision for education, awareness raising, and empowerment of communities. And then finally, honorable members, we request that these considerations be taken into account. In our submission, we have proposed wording changes to the bill to assist in ensuring that the principles and concerns have been effectively addressed. And in this regard, we wish to direct in particular to the wording that we have suggested around the principles section. As Dr. Oliver said, the principles that are there are sound, but we have suggested a number of additional ones that will ensure that the objectives of the bill are reached. And with that, we thank you and invite you to discuss any of these matters with us going forward. Thanks, Madam Chair.
Thank you so much, Center for Environmental Rights, on your presentation. Members, I believe I should think there's consensus that we first deal with the first two presentations. while we are still fresh than to wait until the end. Otherwise, you'll miss some items. Can I get the show of hands of colleagues who want to raise issues, comment on the two presentations by the Presidential Climate Change Commission, including the Center for Environmental Rights? Can I see hands? So those far we have Honorable Singh and Honorable Bright. In that order.
Thank you very much, Honorable Chairperson, and thank you for giving us this opportunity. And thank you to the two presenters. I'm going to be very brief because I know time is against us. But just a question to Dr. Olver on behalf of the Commission. I would just like him to explain the role of the PCC vis-a-vis the role of the Department of Forestry, Fisheries and Environment. Because I see quite a few roles are being passed on to the PCC. And I just want to see where's the intersection and how does it delineate the roles. So that's the one question to them. The second question to Center for Environmental Rights and Life After Coal is the issue of the issue of trees, planting of trees. Now, I note that around the world, it seems like planting of trees is being allowed to offset, as part of carbon credits. Now, I don't believe you can buy your way. Western countries buy your way by planting trees, mainly in Africa and other areas where the land of the indigenous people, which is being used for agriculture and pasture, is being taken away. So what's your views on this carbon credits issue that's being allowed currently? Thank you, Chairperson.
Thank you, Honorable Singh. Honorable Bryant, over to you.
Thanks very much. Yeah, I'll also be as brief as possible. I think there are a couple of themes that are already starting to come through. One of them in particular, something that we've raised previously, the costs involved with rolling out many of the sections of the bill that have been presented in the draft form, in particular developing these strategies within smaller municipalities, etc. And I think the other one is the need for more specificity when it comes to certain sections. And I think perhaps certain things will need to be carried forward in terms of regulations and others in terms of the bill itself. But my one question is just with regards to the presentation from Dr. Olver, where he mentioned the recommendation that the Presidential Climate Change Commission fulfills a role in terms of building consensus between social partners. Can he be a little bit more specific here in terms of what social partners he's referring to, and where this suggestion in terms of providing the Commission with the mandate to fulfill this function would come from, and how they would envisage playing that role? Thanks.
Chair, I raised my hand.
No, I can see you. I was about to recognize you. Proceed, colleague.
Thank you very much, Chair. Good morning, everyone. Specific to our climate change people, I've had the honor of joining you for 2 sessions, and I really can thank you for the hard work that you've done. I've experienced what you're doing. Chair, I have a comment, sort of a question that I don't have to answer, but I do want to put this in. I listen to everything, and everything is valid, and yes, we have to do this, in my understanding, because we do not adhere to the existing laws, which is the enforcement of the laws. Because if the coal mines rehabilitate, if the fuel fossil power stations do what they have to do and adhere to the admissions, and we wouldn't have the problem of climate change, if I understand this correctly, as we do everything in this world. So by making all these new laws, again, I see the enforcement and the penalties is there. It takes backseat, whereas I believe for us to actually combat and fight climate change, this is just an opinion, is to ensure that the enforcement is happening, and that should be bigger than just making our policies, which is a great policy, but we wouldn't have to do this if the enforcement was there. So somehow we must in this bring in the serious penalties and enforcement, and I know it's not our job to enforce it, but that is the problem. And I do think we need to take a much stronger stance on the enforcement of the policies, the new ones or the current ones. Because if people don't adhere to now and we make this climate change bill, I can't see that they will adhere and being enforced in the future. Thank you, Chair. That's my comment.
Honorable Mkono, over to you.
Thank you, Honorable Chair. I don't know whether I'll be audible enough because of the load shedding, but thank you for the presentation. Mine is on the first presentation by the Commission on the transition, which Dr. Oliver indicated that it's going to affect workers. I'm just checking because I have a network problem. Maybe I missed out if there is something that indicates to us how can we navigate towards securing jobs for the sections that might be affected. And I fully support, and I think we need to engage more on the climate action. I mean, the terminology, climate action plans to climate change response implementation plans. Engaging also even the level of local government. On the second presentation, Honorable Chair, there is this. I know that we are talking about the emissions, the emission reduction from 45% in 2030 and net zero by 2050. The plans and the programs to how can we make them as effective as we can so that we can achieve that? Because from now to 2030, it's only 8 years. Maybe 2050 we can talk, but from now to 2030, we only remain with 8 years. In these 8 years, if we can have suggestions that directs us to the practical methods that can really assist in this in achieving the net zero emission by 2050. Thank you.
Thank you. To the Center for Environmental Rights and others, I should think one will start by commending you for such a detailed, substantive input. However, as one goes through your submission and also heard you now, one cannot help thinking whether you made submissions of this nature to the department during their process. Or is it this the first time you are commenting on the bill? One is asking this because one believes there should be a good working relationship between you and the department as you share the same forum on the Presidential Climate Commission and fight the same enemy, which is climate change. So one would like to hear your view to that effect. The same thing, Dr. Oliver, I'll ask the same question, though Honorable Singh tried to do that. DM Sochi, you'll recall, we timelessly asked this question about the Presidential Climate Commission, and to us, it looked like it's part of the executive. But then I'm glad that what now you are proposing, you are trying to also bring that independence from the executive. That's the one thing that is when I read your presentation at some point in terms of the accountability. You want to move that responsibility to Parliament, which is one thing that one would like to commend you for that. But still, you indicated that when you started this process, but the time the bill, maybe I would like to get the department's comment on this DM and the DG to say these things that they are proposing to us, this was supposed to have been part of the bill as it was introduced to Parliament. And then it comes to that question that I've asked several times to say, how do you infuse the work of the Presidential Climate Change Commission in your area of work? Because we know you are also hosting them in terms of the resources and the rest. And then, because one is of the view that had their inputs been incorporated in the original bill, we could then be giving the other people to comment because they are part of the system. And then why then didn't you then take your views and consolidate them into what you submitted to us? So these are the issues that I want both the Commission and the DG to respond to. But I like the fact that now in the presentation that you presented, you are trying to zoom out that independence because as you are now, you are seen as part of the executive because you are appointed by the president, who's then the chairperson of the executive. Then there might be some issues that you are not really independent according to certain stakeholders because you are seen as being part of the system. Those are the issues that I want to also raise so that you can respond to them. Can I start with you, Dr. Oliver and the team? Then the colleagues from the Center for Environmental Rights will then come later. Over to you, Dr. Oliver.
Thank you, Honourable Chair, and thank you to the members for the questions. These are extremely pertinent issues that you're raising. So just to say to the Honourable Singh, the role of the Presidential Climate Commission is purely advisory. We are not a regulator or an implementer and are not taking any functions away from existing government departments and agencies. Our job is to advise, provide independent advice on any matter relating to the climate transition, including the just transition. That advice, sort of crosses across a number of departments, and we can give advice on any matter. And this is an issue that I think a number of departments have been struggling to understand. They see us doing our work and coming up with recommendations, and they think we are taking away their line function. That is not correct. We're simply acting as an independent sounding board, which is there to augment and enhance the work of other agencies and departments. With respect to the Honourable Bryant's questions, this term social partners in the South African application, it's really come out of NEDLAC. So, NEDLAC is composed of social partners, which consists of organized labor, organized business, government. It was initially a tripartite structure, and then later the community chamber was added to that. So, that's the NEDLAC conception of social partners. we use a slightly broader conception. So if we were to unpack social partners, we would include, for instance, youth as a sector. We would talk about local government as a separate sector. Obviously, it's within government, but it's a very important sector. We try and target them specifically. We consider the faith-based community to be a sector, one of the social partners. And very importantly, we consider the academic and research community to be another social partner. So you can see we've got a slightly broader conception. And the way that the commission is composed, it very deliberately, I mean, this was the foresight of the president and the cabinet decision that set it up. They've, actively brought representatives from all those sectors to sit on the commission. So in the work that we do, I mean, you've got all these very contentious different viewpoints which have to try and find common ground before we make any recommendations. And there's always a bit of to and fro and compromise, and then we reach agreement. So we are already actively doing social compacting. We're, in the climate space, we are one of the social compacting institutions. We build consensus, and we do it by creating forums for people to discuss issues and hear each other. I mean, it's partly listening and partly understanding where everyone's red lines are and where is the common ground that people can find. So, that's the sort of nitty-gritty of the process, and I would love an opportunity to discuss it in more detail with you. We think it's very important. I mean, so our job is not just to mobilize the science and provide advice, but it's importantly debate it, create the space for public engagement, not just at the level of the commission. I mean, the commissioners always keep saying, we are not the sole representatives of the sector we come from. So, in the way you do your work, you need to actively reach out to shop floor representatives, to community organizations, etc. So, in fact, the social compacting process as a whole is bigger than just the commission. It's a society-wide process that we're trying to engender. So I hope that clarifies it, Honourable Brian. With respect to Honourable Weber, I completely agree. I think enforcement of policies is essential. There's no point in making them and legislating them if they're not enforced, because it simply just devalues the integrity of the state and the legislative framework. With respect to the Honourable Mkhulu, I think you're asking the crucial question. So how do we navigate this transition in a way that creates jobs? We've got some really excellent climate modelling that's been done. In fact, there are various modelling exercises. There's a group at UCT called the Energy Systems Research Group. There's a project that's been running for a few years at the National Business Initiative. There's the team at CSIR, which is in the Energy Research Centre. All of them have got different models, and there are a few others I haven't mentioned. And part of these models is that they estimate the employment impact as we downscale certain sectors and upscale other sectors. The good news is that all of them show that there is a net positive impact on the transition as we go into greener technologies. And that's because, we're moving away from extractive fossil fuel dependent industries into a more decentralized energy system with a lot of opportunities for employment in the manufacture of renewables, battery technology, the hydrogen economy, the move to electric vehicles. And the models show, the net impact is positive. Obviously, that's not enough for workers. We need to show them practically how are we going to transition and where do the opportunities lie, and how is government going to support workers with the skills and the job placement schemes and the social protections so that we deliver this promise. No one must be left behind in this transition. So I think it's a key issue, Chair, that we would love to come back and present in more detail with you. I think at the level of this committee, we should interrogate these models and talk practically about how how do we ensure this just transition is a real transition? It's not just something we talk about in these rooms. Chair, you've asked some questions about how the PCC's work gets taken up by the department and by other organizations. I mean, that is a work in progress, and we're in the process of building working relationships with a whole range of government departments. DMRE, DFFE, DPE, DTIC, all your core economic ministries, Department of Employment and Labour, Department of Higher Education and Training. I mean, these are all integral to this climate transition. So just to say, it's a work in progress. And in future, when we come and report to this committee, I think we must also report on that work and how it's succeeding. Thank you.
Okay. Brendan, are you starting?
Thank you, Honourable Chair. I'll start and then hand over to Wandisa. So I think the question posed by Honourable Singh is a very important one around carbon credits. And we certainly have grave concern about that notion and how it gets used around the world and potentially here. So firstly, planting of trees, I think something just to bear in mind is that tree planting may be a form of carbon sequestration, but it's not necessarily appropriate in all ecosystems. In places where grasslands, for example, naturally occur, it's better to restore those kinds of ecosystems than simply planting trees. And also to note that forestry plantations of, say, pines are not the same as planting trees effectively for carbon sequestration. But I think more problematic is that we look at what we call the long and the short carbon cycle. So the long carbon cycle is we effectively digging up fossil fuels that were trees millions and millions of years ago, burning those and putting that into the atmosphere, and then hoping to take that again out of the atmosphere using the short carbon cycle, which is through vegetation. So it does not really equate. Planting trees does not equate and doesn't counter the emissions that come from burning greenhouse gas emissions. So carbon credits are something that potentially can be terribly misused. And then, these kinds of schemes that are used to supposedly sequestrate carbon, in fact, really do perpetuate many of the human rights abuses that Honourable Singh alluded to, including land grabs and that kind of thing. So we need to be really very careful with this concept. And it is a way of emitters buying their way out of taking up the carbon space that they are. So there's simply no substitute for reducing greenhouse gas emissions from fossil fuels as urgently and as effectively as possible. In terms of the question and the comment made by Honourable Weber, just one aspect of that. So we do have the pre-existing environmental laws, including air quality, and the Air Quality Act has sort of indirectly started addressing climate change, but that set of laws doesn't necessarily address the full spectrum of climate response that we need, and that's why we need this act as urgently as possible. But yes, to underscore the grave importance of ensuring that there is proper enforcement. And that's why we also suggested a range of enforcement mechanisms that can hopefully support and assist the department to do that enforcement. And the department will probably need political will behind it and sufficient resources to do that as well. And then in terms of the question by Honourable Nklunu, we have this very short space of time till 2030. So what do we need to make sure we can achieve those reductions? Firstly, we need to get this act in place as quickly as possible. The sooner it is there, the sooner we can start to implement some of these measures. We need those clear interim targets. We need certainty around the targets. Our NDC has a range. The upper range is sort of commensurate with a 2-degree temperature increase, and the lower range commensurate or closer to the 1.5 degrees safer limit. So we do think that lower range of the NDC is the one that should be implemented and looked at. And then again, the enforcement. I mean, the way things are looking at the moment, the true limiting of greenhouse gas emissions is going to come through in 2026 via the Carbon Tax Act. That's too little and it's too late. So we need to see, when this act comes into place, the ability to curb excess greenhouse gas emissions from the point that the act comes into being. I'll hand over to Wandisa. Thank you.
Thank you, Brendan. Thank you, Chair, and honorable members for your questions. Chair, I will just address the question you were raising on our engagement with the department on the bill. And the short answer to that is that we have been engaging with the department throughout these processes in relation to the climate change bill, making substantive comments. In 2018, when the first version of the bill came out, we made substantive comments on it and participated in all meetings that were hosted by the department at the time. And when this bill came out, again, we've been engaging with the department and making comments on other related issues on the bill, such as the NDCs, access to GHG data under AQUA, and throughout the process, we've been making comments and engaging. So this is not the first time we are coming with comments of this nature, as we have raised similar issues in the past. Thanks.
Thank you. Thank you so much. I don't see any further hands. That means the colleagues are cool with their responses. Then we can go to the next presenter. I'm trying to quickly. Chileka, who's the next presenter?
Dr. Muller, Chair, from Veld.
Dr. Muller, can we hand over to you?
Is the coordinator going to put up the presentation, or do we need to do that? Can we get clarity?
Were you not given the sharing rights?
I did, Chair.
Check. Can I be given the sharing rights, please?
So that you are able to control your presentation.
Yeah, sorry, there are two of us presenters. I think they've given the sharing rights only to one. If you could just quickly hand over.
Okay. I assume you both have now.
There we go.
Yes.
Okay, excellent.
Dr. Miller.
Thank you very much, Honourable Chair, and greetings to the Honourable members. Some familiar faces from one time ago, as Dr. Olva also said. It's very grateful for the opportunity to present. I need to clarify that there are two of us making the presentation. We are bringing complementary perspectives from both practice and academia, because we have both worked in this area in a number of different contexts, and have not previously commented on the draft of the bill, but since it is now in front of Parliament, felt that it was appropriate to do so. So if we can just go to the next slide to check what we will cover, I'll explain. This should be a very short presentation. You've got a very complex subject and a very busy agenda. We'll try and keep it brief. We want to focus on the use of the just transition in the bill, and consider the powers vested in the Minister responsible for environmental affairs. I will cover those two issues. And then Dr. Miller will look at the costing of adaptation plans and questions about how the Presidential Climate Commission is formally constituted to address these very important issues. We have provided a written submission, but we've adjusted the order here just to ensure that we can be coherent and efficient in our presentation. Next one. So turning to the question of the definition in the Act of the just transition, we believe it's very important to get this right, because this will guide the work of all the agencies that are involved and the way in which the public contributes to the work of the climate transition through all the different agencies. And we look at the current definition provided there on the screen, which omits a very important issue. As we move, the transition means a shift towards a low carbon, climate resilient economy and society, ecologically sustainable economies and societies, contributing towards the creation of decent work for all, social inclusion and the eradication of poverty. We miss the one important issue: who pays? And here we do need to understand that we are talking both at a local, that's a national level, and at an international level. And at a local level, we do need to understand that the costs of the transition impact on different communities and different people and different institutions in different ways. And that it's very important that we should clarify how much do the wealthy contribute compared to the poorer individuals, how much does big business contribute in relation to small businesses, the rural and urban impacts and costs and benefits, how do large municipalities handle these issues compared to small, and very importantly, how do the costs imposed on current generations impact on what future generations are going to have to pay. That all has to be dealt with at national level, but equally internationally, we do need to recognize, as the country which has the highest carbon intensity effectively in the world, for historical reasons, which didn't actually always benefit the people of the country, we need to consider which countries have made the larger contributions to global warming, including some of their activities in the periphery in the south, and which should pay more of the costs. Particularly, how do we balance the costs paid by the developing countries and more developed countries, the global north and the global south? And to address this, we suggest that it is very important to introduce a formal requirement into the law to say that the just transition includes consideration of the way the costs are distributed across and within countries. And we propose that the definition to be used should include explicitly that question of the distribution of costs of the transition if we are going to achieve a just, which means a fair transition. Next. So that was the first point of the four. The next one is a much more parochial point, but arguably a very important one, and it's already been referenced by the CER, discussing the role and the constraints on the minister who is currently responsible for this area. And we suggest that the bill as it currently stands, by allocating this wide range of powers and responsibilities for climate change, mitigation, adaptation, to the minister responsible for environmental affairs, is actually misguided. There's an inherent conflict of interest. Those of us who were involved in the drafting of the Constitution will remember how to the discussion about balancing the protection of the environment and the promotion of social and economic development, recognized as being a tension in government and for government, and to place the responsibility for both protection and promotion, protection of the environment and promotion of development is, we would submit a really impossible prescription for a minister. We believe that the department's DFFEA is really not structured and cannot have the role and competences to lead the identification and evaluation and prescription of all these alternative social, economic, and technological interventions required. It is actually unreasonable and unfair to place all of these responsibilities and the contention involved in them in the locus of one ministry and minister. And we believe in particular that the powers proposed would actually enable the minister responsible for environmental affairs to intervene in areas well beyond the competence of their department, and there would be inadequate oversight. So we look at Section 28, which simply says, follow such consultative processes as may be appropriate. That really isn't adequate for decisions that could affect whole sectors of the economy. Next. We believe this can be dealt with very easily, but it does require a substantial change in approach. And we would simply submit that the change in approach that we're suggesting reflects the way that major economies and administrations from the USA to the UK and the European Union have all adopted. And that is to separate the environmental function, which is essentially a protection and custodian function, from the economic, social, and technical functions involved in running the economy and protecting and enhancing the interests of groups in society. And we suggest, therefore, that the ministerial responsibility for climate change mitigation and the promotion of a just transition should properly be allocated to a minister in the presidency tasked to coordinate economic, social, and technical, and then the environmental department as well. We believe this will also help to counterbalance a problem that we've identified, which is that there is significant influence of external groups that have, not improperly, but they are single-focus environmental lobbyists that have preferential access to the Department of Environmental Affairs, and that has already resulted in some very expensive public policy responses that would have been better advised if a broader perspective had been adopted. So the practical proposal we make is to amend the bill to include an additional definition for a minister in the presidency or a coordinating minister, amend the relevant sections of the bill, and create the appropriate administrative structures to enable that. So those are the 2 points which I'd like to submit, Honourable Minister and Honourable Chair and committee members. And over to my fellow presenter.
Are you related to the fellow presenter? I just for interest sake.
Yes, Honourable Chairperson, we are related.
Honourable Chairperson, the intergenerational issue is a very hot issue in climate policy, so we'd like to feel that we're a physical representation of the intergenerational approach.
Yeah, I can see it's in the family. It's very interesting. But to you, co-presenter.
Thank you, Honourable Chairperson. Good morning, Honourable Members, Deputy Minister, colleagues. I will just talk to the second 2 points of our submission. Just to note, I'm not sure if my co-presenter mentioned that the numbering in the presentation is slightly different to the numbering in the written submission. This is because we thought this structure made a little bit more sense. So the third point we wanted to talk to was the issue of costing. And I should also add, and I'll mention this as well with the fourth point, that some of these issues are matters of concern relating to the broader policy space, relating to the just transition. So not just this bill, but obviously in this particular case, that's the focus of our concern today. So the basic problem is that there's no provision for costing in the bill, no substantive provision for costing that we can see. It's a fairly standard principle of good practice in policy making that policy changes and interventions and regulations should be costed whenever possible, and that's for fiscal reasons, partly, but also in order to compare the relative costs and benefits of different options. But within that, it's also important to think about distributional implications. A number of the prior speakers, both from the PCC and the CER and a number of members, mentioned the importance of thinking about inequality, distributional effects, and so on. And we strongly agree with that. But in order to get a proper handle on distributional implications, one needs to have proper costings. So as my co-presenter was mentioning in one of the previous points, thinking about who's going to pay. Okay, so this comes into the issue of the definition of the just transition. If you exclude the costs from the definition, then that's already a problem. Because potentially then you can have a just transition that in fact is unjust once you take into account fiscal and other considerations. But more specifically, when we're thinking about any given set of interventions or even individual intervention to achieve the objectives of the bill, it's important to be thinking about cost, fiscal implications, and distributional implications. So just to give you a sense, and this is essentially government policy. So, for example, consider this first quote that I took from the Government Technical Advisory Committee, GTAC at Treasury. It says, in South Africa, Cabinet has decided on the need for a consistent assessment of the socio-economic impact of policy initiatives, legislation, and regulations. And that was back in February 2007. The guidelines for that were adopted in 2015. And I just used that particular quote to mention that it's not just about, as it says there, comparing estimates of the costs and benefits of different interventions, but it's also crucial to analyze the costs and benefits to different groups. And so quite rightly, there's been a concern with the employment of workers in what one might call legacy industries, coal mining and so forth, which are likely to decrease in size in the future. But of course, that's just one dimension of the costs of the transition. And there are many other dimensions that must be taken into account if we're going to achieve the objectives of, for example, reducing inequality and eradicating poverty, which were mentioned in the previous presentation by the PCC. So that's the problem. What is the solution? Well, we're trying to be very specific in terms of what we put on the table. Of course, when it comes to drafting of legislation, we appreciate that there might be different approaches and there might be some technical considerations that the drafters might have. But we've given the committee, we've sought to give the committee concrete options to work with. So we propose two particular amendments. The first is in addition to Section 15. Which pertains to provinces and municipalities, and that's the Section 15.2a, which says identify climate change response considerations and options, and we say and the estimated costs based on the best available evidence and information. So it's not, and again, this is a standard public policy principle, it's not actually especially helpful to just look at possible policy options. One needs to have some kind of costing. What is going to be the cost of these options? And costs should ideally be broadly defined to cover the kinds of socioeconomic impact issues alluded to on the previous slide. The second proposed addition is to Section 17, which pertains to national strategies. That's 17.2, and we propose to add the subsection E. So 17.2 says the adaptation scenarios must, and then there's a series of requirements. We suggest adding 17E, include estimates of the costs of implementing the adaptation policies underlying the scenarios. This talks also to I think, a question from one of the honourable members earlier about municipalities. What are going to be the costs to municipalities? But it's not just about municipalities, it's actually at the national level as well. So that's our third point. The fourth point is about requirements for members of the Presidential Climate Commission. And on this, honourable members, I should say that even more so in this case, this is a reflection of concerns about the broader policy process and the dynamics in that process that are taking place in the country at the moment. So the principle here is very simple, and in general, it's quite hard to find anybody who will explicitly disagree with this principle, but the implications are not always followed through on and appreciated. So the principle is that those who advise on and make decisions about South Africa's approach to climate change must have the public and national interest as their sole priority in the provision of such advice or making of such decisions. We presume that is the purpose of the bill as well, namely to advance the national interest and the well-being of all South Africans. Now, our concern is that there are numerous experts who have informed the country's strategy that have material undeclared conflicts of interest that call into question their suitability to advise on matters of public and national interest. As I say, this is not, in fact, specific to the existing Presidential Climate Commission, but more broadly to the dynamics around this policy issue in South Africa. For example, experts who have been advising the president on these matters and so forth. We're of the view it would be remiss of legislation not to address this. So again, we aim to provide a concrete proposal, and we propose the following addition. This is Section 2. Which is about the composition of the Presidential Climate Commission. We're happy with, very happy with the first two clauses. We suggest adding Clause C, ensure that appointees publicly declare all potential conflicts, including funding from industry, domestic and foreign non-governmental organizations, as well as foreign governments and multilateral agencies, and where appropriate, exclude individuals whose conflicts may compromise their ability to prioritize the public and national interest in a credible manner. This is something that, in fact, we think should be happening across the spectrum on any policy issue, actually, honourable members. But we're particularly concerned with the issue of the just transition and associated policy decisions. It is one of the most important policy issues, if not the most important policy issue for South Africa over coming decades. And we think it's crucial that whilst there are broad engagements, there are a broad range of perspectives that are brought into these discussions and so forth, it's important that conflicts of interest are declared, and where those are of sufficient degree, individuals are excluded from roles that require them to prioritize the national interest rather than simply represent the opinions or the interests of a particular stakeholder body. So, honourable member, those are our four submissions. As we said, we'd like to keep it short. The written submission is a little bit longer. Thank you for your attention.
Thank you so much, Sian. Then let's get the next presenter.
Hi, good morning, Madam Chair, honourable members. Thank you for inviting us to be here and to contribute to this historic piece of legislation. My name is Susan Comrie. I'm a journalist with the Amabungane Centre for Investigative Journalism. I'm standing in for our advocacy coordinator who left at the end of August. So I'm just here alone, and hopefully I can field any of the questions that you might have. So a little bit about Amabungane. First of all, we're a non-profit independent newsroom. Our goal is essentially to produce world-class investigative journalism. But we also have a second task. We also campaign and litigate for information rights, access to information, and then also for media freedoms, which we consider the sort of lifeblood of the work that we do. Now, our goal in being here today, the climate change bill, as we see it, represents a once-in-a-generation opportunity to tackle effectively the biggest global threat of our time. And what we are hoping is that we can convince you that transparency and access to information needs to be baked into the climate change bill, so that this, incredibly precious natural resource, our carbon budget, is used for the benefit of the whole country and not just used to kind of line the pockets of private companies and their private shareholders. Now, I want to start with a quote from our written submission, which all of you will have access to. We've said climate change is an issue like no other. There is little to no margin of error. If South Africa fails to achieve appropriate greenhouse gas emissions, appropriate greenhouse gas emission goals timelessly, the lives of all South Africans living and yet to be born will be placed in jeopardy. I think, Chair, that you have also outlined very clearly what's at stake if we fail to get this right. Now, in terms of in terms of the bill itself, there's a lot to like in the climate change bill, but the bill also demands a huge amount of the minister. I mean, the minister will be required to take in vast amounts of information from every corner of the economy and come up with thresholds that will fairly distribute our scarce carbon budget. It also creates a vast amount of discretion for the minister in making those decisions. And this is just one small example that I wanted to show you, where we talk about setting greenhouse gas emission thresholds. It says that this needs to be based upon not just what mitigation technology is available, but also what's feasible. Now, I think if we can just look at Eskom to see how that might play out. For instance, Eskom is subject to the minimum emission standards, which limits the amount of SOx, NOx, and particulate matter that their power plants can pump into the environment. Now, the technology is available to limit those emissions, but it's expensive. And so Eskom continuously says it's just not feasible for us to implement that technology. And I would say that this is, despite the fact that we know that coal-related air pollution kills around 2,000 people in Mpumalanga every year. So, the risk of having this level of power and this level of discretion in the hands of the minister creates massive opportunities for corruption. But I think what worries me more is not that so much. What worries me is that the level of discretion that's baked into this bill also means that the minister and their officials are going to be lobbied, are going to be bullied, fed corporate misinformation at every turn, and threatened with job losses by every major polluter in the country. I mean, I think, just take a look at Sasol. 22nd of August, Sasol comes out and says that, the upcoming carbon tax is going to pose a threat to its business and that it may need to scale back its operations rather than decarbonize. Scale back operations, i.e. job cuts. The following day, Sasol announces 147% increase in its profits. There might be good reasons that these two things can coexist, but the public needs to be able to critically interrogate these kinds of claims. Particularly when the minister's decisions, either to grant an exemption or to alter a carbon threshold, is going to translate into hundreds of millions of rands in profits for private companies. Now, our argument is not that we should limit the amount of discretion that the minister has. Rather, we're saying that there needs to be a highly transparent process around how that discretion is exercised. I mean, we know journalists, members of parliament, civil society, we know from investigating state capture that having discretion without transparency is really a recipe for abuse. Sorry. So what does the Act say? We're essentially going to focus on Section 31, which controls, which talks about access to information within the Act. Now, it's very brief. It talks about how disclosure should be in terms of the Promotion of Access to Information Act, PIA, as most of us know it, as well as the Protection of Personal Information Act, PAPIA. And we argue in our submission that this is wholly inefficient to address the scope and the urgency of climate change, and that what we really need is a new regime of information disclosure to be baked into this bill. Now, I can give you my perspective as a journalist of why PIA and PAPIA are insufficient in this perspective. I mean, a lot of the time what journalists will tell you, requests get ignored. Very often it's not that an official is trying to withhold the information. It's just that very often you don't have a dedicated information officer within a department. That means that someone else who has a full-time job is having to field PIA requests when they find the time. Responses often get delayed. It can sometimes take years to get information. One example I can give you, we were asking for information about a yellow plant tender at Eskom. I think we submitted the PIA in 2018. We got the information in July this year, so around 4 years after we had initially asked for information. Now, another problem that we come up against with PIA is that it contains mandatory protection of third-party commercial information. So what that means in practice is when we submit a request to a government department, they will then need to write to the third party who's potentially affected, and that normally means a company. And very often a company or their lawyers saying, we don't want that information in the public domain is enough to prompt a refusal. Now, when there's a refusal, you have to go through the internal appeals process, if there is one, but ultimately what's happening is you're ending up in court, having to fight for this. Now, I will say that overwhelmingly, when we have gone to court, the courts have ruled that we do have a right to access the information, but it is an incredible administrative and financial burden that's placed not just on us as NGOs and media houses, but also on the state, who ultimately has to carry the costs for these legal challenges. Now, one example that I can give you there, a couple of years ago, we had PIA'd the Department of Mineral Resources and Energy for a list of mining rights that had been transferred in terms of Section 11, which is a relatively straightforward, piece of information that they should have access to. Our application, our PIA, was refused. We had to go to court. We got a court judgment saying that we were entitled to the information. The department still did not comply. We had to go back to court again for a contempt of court order, in order to, where the judge actually held that the officials would be held personally liable for up to 100,000 Rand if they didn't provide the information. I have to say, to date, we've got some of the information. We still do not have all of the information. One of the biggest problems, though, with PIA is that, and what makes it particularly inappropriate for climate change, is that it results in information being disclosed on a one-to-one basis. So it's one department disclosing the information to one journalist. It's not disclosing that information to many people. And there's no requirement that anyone who receives information in terms of PIA has to make that information public. Now, the introduction of PAPIA is really kind of just making this problem worse. What we've seen is that PAPIA has this kind of chilling effect, that whereas officials were somewhat reluctant before to provide information, they're now too scared and are erring on the side of secrecy, erring on the side of saying that PAPIA prevents them from releasing that information. Another really significant problem that applies with PAPIA is that it applies to juristic persons. In other words, it applies to companies. Now, this can sort of essentially result in companies saying that they have a right to privacy and shielding any release of their information under that clause. Now, when we're talking about companies that are tapping into our carbon budget, where their emissions are stealing from our carbon budget, you really cannot have a situation where they're allowed to hide behind and use PAPIA as a shield. But it's entirely conceivable that that is how it would play out. So to give you an idea, if Section 31 of the bill remains unchanged, what would a typical request look like? First of all, we would submit a request. It would have to go through 30 days, then 60 days where there'd be an extension. The department would have to write to the private companies whose information, would be potentially disclosed to us. Eventually, we would end up having to file affidavits in court. The department, the private companies would all have to file affidavits as well. Eventually, we'll get a court date. And several years later, we might finally get a judgment that says that we are entitled to that one piece of information that we were looking for. Now, that could take 5 years. In that time, the company is continuing to pollute, is continuing to pump greenhouse gases into the environment. And the problem is that at the end of the 5 years, what might happen is one journalist gets one piece of information. But the reality is that you have 500 other journalists, members of civil society, people who are impacted by climate change, who also want the same information. And they're not just asking about one company, they're asking about, say, 50,000 major polluters in the country. That burden that this would place on the department is not sustainable. And at the same time, looking at the bill, government just does not have the capacity to kind of single-handedly police all of the companies that are going to be submitting information in terms of the climate change bill. The only way that we can ensure that companies comply is by guaranteeing that the media, NGOs, civil society, parliament, even other companies and the state, that we all have access to information so that we can all police this bill. That's really why we are proposing a completely different regime be introduced through the climate change bill. So what are we asking for? What we're asking for is proactive disclosure. We're asking that information that's provided to any organ of state in terms of the Act must be made accessible to the public within 10 days through a proactive disclosure mechanism and without the requirement for a request. Now, I know that sounds somewhat radical, but essentially what we're asking for is we're saying we want to see the decisions that are taken by the minister. We want to know how those decisions were taken. We want to know what information was used that was fed into that decision-making process. And we want to know to what extent companies are complying with the minister's rulings. So we have in our submission, we have a slightly more detailed version of the full text that we're proposing. This is our proposal for what a new Section 31 could look like. I'm not going to go through that at the moment, but I am happy to go through it at the end, or if anyone wants to follow up with us and ask for information or ask questions, we're happy to do that over email as well. But as I said, this might feel like a radical departure, but really if one looks at the Bill of Rights, if one looks at the precedent that's out there, this really isn't that much of a radical idea. The Bill of Rights, as we know, says that everyone has access to any information held by the state. We operate from a principle in South Africa that information should be open, that we have open justice, open administration, that the state has to take steps in order to close off that information. Now, we can see from the way that PIA and POPIA work in practice that this is falling far short of that principle. Now, it's also worth mentioning the Declaration of African Commission, the Declaration by the African Commission for Human and People's Rights, that they have explicitly outlined that this is what government should be aiming for, proactive disclosure. And they really specifically draw out a line here and saying, even in the absence of a specific request, government should be publishing information. Now, I'm happy to say that there is a really good example of government embracing proactive disclosure already in South Africa. Many of you will know about the UPL warehouse fire in July 2021. A warehouse containing sort of millions of tons of pesticides was set alight in Cornubia, in Durban, and it created a kind of unprecedented environmental disaster in the area. You had pesticides, some of which are carcinogenic, some of which are mutagenic, flowing into rivers, being sent up into the air and kind of blanketing the whole area and creating, potentially a sort of public health emergency. Now, in response to that, the Department of Forestry, Fisheries and the Environment, the provincial department as well, set up an information portal. And this really gives us a sort of template of what we would like to propose for the climate change bill. It's a public website. I've given the website address at the bottom here. If you haven't had a look, I'd really encourage you to take a look. You just need to create a free login. And this website really discloses everything to do with this disaster. It includes directives that have been issued by the department. It includes the department's correspondence with the UPL. It includes compliance reports, presentations that have been given to the officials, scientific results, toxicology results, even things like an inventory of the pesticides that were stored in UPL's warehouse, which under normal circumstances, if you tried to ask for this information in terms of PIA or POPIA, you would be told that that's confidential. Now, what the department luckily has provided this really fantastic explanation on that website of why they chose to embrace proactive disclosure. And I just want to pull out a few of the lines that they have here. What they've said is that the page was developed primarily to ensure the free flow and access to information and to enhance the transparency of actions in this matter. I love that line, the transparency of actions that government is taking. This page serves to provide an opportunity for various stakeholders making up the team to provide reports to the public domain with a joint objective of instant dispersal of information and openness to all interested and affected parties. Again, recognizing this idea that if you have one place that various government departments can use in order to provide information to the public, this works far better. Further, that all information and reports received should be disclosed are done so in a coordinated manner with equitable access to all interested and affected parties. This repository will avoid a situation where information is being provided piecemeal. And I think that's such an important point that they've made here. You know, we are very fortunate as Amabungane. We can afford to go to court, to sue, to get access to information. But, you know, most NGOs are not in that position. Most individuals who are impacted by climate change are not in a position to do that. And so essentially, to get back to what we're asking for in terms of proactive disclosure, essentially what we're saying is that we want a public information portal where all information which is generated as a result of the climate change bill is proactively disclosed by government, so that no one has to go to court and get a court order to find out how the country's carbon budget is being used. And so that everyone who's impacted by climate change, which is everyone, has equitable access to this information. We have recommended in our wording that any reference to POPIA be removed from the bill, but that to the extent that POPIA is included in the bill, we would propose that that you explicitly create a carve-out for mandatory disclosure. You know, if left unspoken, POPIA, which has an override, will essentially apply, and which could result in a sort of virtual blackout of all information related to climate change. And I want to just finish off by going back to the quote that we started with. You know, climate change is an issue like no other. There is no margin of error. You know, our carbon budget it's about to become, you know, the most precious resource that the country has. It has to sustain us for the next 28 years. And unfortunately, we know from the COVID-19 pandemic that there are unscrupulous people who will treat a global emergency as an opportunity for self-enrichment. Now, climate change is an emergency on a far greater scale than COVID-19, and the opportunities for bad actors, I would argue, are also far greater. The job of managing this resource, our carbon budget, cannot be left up to one minister and one department, especially when they are relying on companies to monitor and self-report any transgressions. The stakes for everyone are simply too high. It needs all of us. It needs Parliament, it needs media, it needs civil society to act as watchdogs. But we can't play that role if we're kept in the dark. And what we're arguing for is we need transparency, but we also need you to enshrine that in this law. Thank you.
Thank you so much, Susan. Sincerely appreciated. Colleagues, can we interact with the two presentations from Amabungane and the colleagues from VETS and UJ, the Millers? Can we do that for now? Or you need a comfort break, 5 minutes first? Then we come back.
We can, Chair.
Agreed.
Then, raise your hand. Let's get the 5-minute comfort break. Then we're gonna, when we reconvene, we're going to deal with the two presentations. It's 10:58, 11:03. We'll be back.
Recording stopped. Recording in progress.
Thank you so much. The first hand that I'm recognizing now is of Honorable Singh. I think that's the only hand that I'm recognizing for now.
Thank you, Chair. That was a very quick 5 minutes.
No, it's 5 minutes.
Yeah.
Now it's 5 minutes.
No, it's 5 minutes. No, thank you very much for the presentations by the two presenters. But just for me to get an understanding of their thinking as we as a committee would process all these submissions later. I just want to put it to you sometimes that the focus on just transition and the wholesale loss of jobs without coal-firing power stations is sometimes kind of misleading. Is there not an opportunity for upskilling of many of those that are employed in that sector so that they can contribute to other areas where we provide energy through other means, whether it's wind farming or hydroelectric power or whatever other means are available to provide it. So I'd just like to know your views on the emphasis on just transition, why we want this transition. The other question generally to both of them would be, and I think particularly Johannesburg, Dr. Muller, was the question of funding. Now, do you get an impression, or am I wrong, that in terms of the functions that are to be passed on to municipalities or levels lower than national government, there are no funds to follow those functions? And we know the parlous state in which many municipalities are in. How do you think that can be balanced? Because it's good enough to have legislation, international legislation, but if it cannot be implementation at lower levels, then it becomes a problem. Then with the Amabungane, the question, there was a lot of emphasis on the power of the minister. And if I can use my own words and put it in inverted commas, probably unfettered power. So what suggestions would you have to ensure that that power is restrained, but also that there's adequate monitoring and evaluation? The other question would relate to, the elephant in the room, which I think both of you have raised, which is Eskom and Cecil. What are your views? I mean, personally, I think for far too long we've been going too easy on those two state-owned enterprises. So what would you be your views? And very, very lastly, I think the comments on Popia and Paia, while they may apply specifically to this legislation and how we roll it out, it might be a general issue that we need to take up with government. On what does Popia and Paia actually mean and how we can improve aspects of that. Thank you very much.
Thank you so much, Honorable Singh. Honorable Bryant, over to you.
Thanks, Chairperson. I think I've been covered by Honorable Singh on most points. Just one thing that did come out was this idea of vested interests and that having an influence over decision-making when it comes to legislation. I think it's a very important item for us to discuss and take into consideration in terms of ensuring that, in particular, feedback that comes through from the public and other entities is properly collated, distilled, and used to inform our legislation, and not necessarily sort of curated to suit an existing political agenda. I think that's a balance that we have to strike. And I just want to know from the two representatives from WITS in particular, if they're aware of best practice elsewhere where this has been achieved effectively, in particular to this type of legislation. And if so, what alternative systems they would be proposing in order to achieve that?
Thank you so much, Honorable Bryant. Okay. My issue to Professor Mike Miller and from WITS and Dr. Miller from the University of Johannesburg. Personally, I like your concise and direct input on the Presidential Climate Change Commission and also on the definition of just transition. That also includes the payment of costs associated with it. Colleagues, I should think we must all agree we are being enlightened here. Susan and Mike, can you mute your microphones? Because through one of your microphones, there's a sound that is coming through. Okay, sorry about that. I was still saying, I believe we're being enlightened here. I, for one, Dr. Olva, if you're still here, I'm an ardent supporter of just transition, because some of us, we were fed and educated with resources coming from coal mines. That's the harshest reality, unfortunately, that one we confronted with. Then coming to you, Susan, from Ama Bungan. The access to climate information is currently proposed via the Promotion of Access to Information Act. And I'm glad you raised the Nubia incident in KZN. It's also then, this year doing it subject to the Promotion of Personal Information Act, POPIA, which yourselves, as Amambungane, and the Center for Environmental Rights, you are arguing that it's insufficient, and you are recommending for automatic disclosure. Then the question that I'm bringing to you, Susan, would including the inclusion of automatic disclosure in the climate change bill not be amending the relevant provisions of the Promotion of Access to Information Act or the Promotion of Personal Information Act? I know you are expert in this field. You can be able to enlighten us to that in this regard. So those were my issues that I would like maybe yourselves to comment on. Yeah, that's the issue. Thank you so much. I see you already in the screen, Susan. You want to start? And then the doctor and the Professor Miller will come with. It's okay.
Sure, thank you. Let me try and answer the questions as best I can. Honourable Singh, you've raised this issue around funding and how we'll capacitate municipalities when resources are already stretched. I mean, our view is that there's no amount of funding that can kind of give government the resources to do this alone. When it comes to monitoring this process, policing it, it really is going to take a whole of society approach. There are resources in civil society. There are resources within the media. There are vast resources amongst the general public, people who are willing to get involved, to lend a hand, to monitor this. But that really does require that the information is put into the public domain, and that it's not, that this vast job is not sort of left up to government. That would sort of be my, one of the kind of, the solutions on the funding question. In terms of the power of the minister, yeah, I mean, it's, I'm not quite sure I'd call it unfettered, but I think it's a fair point. Again, how do we kind of, how do we sort of limit that, or how do we limit the risk of that? Again, we would say we limit the risk of that being abused through transparency, through a kind of radical system of transparency that puts all of this information into the public domain, so that we don't have to go and fight for every single piece of information on every single company. So that we can kind of make sure that the minister is taking decisions that are based, in terms of the bill, sort of saying that it's on the best available information, and that it's not being based on kind of backdoor lobbying or pressure over sort of certain kind of corporate bullies. In terms of Eskom and SASL, that your comment that we go too easy on those two state-owned entities, yeah, I would agree with you. I think, you know, we see over and over again that issues around air quality, for instance, get pushed back. You know, we've seen that those that technology has been sitting in Eskom's capex budget. We saw that those pieces of equipment were there. Promises were made to those communities that they would start to limit the amount of damage that those power stations were doing. And then see what we see happening is consultants come in and they say, well, you need to cut your budget, let's cut it. I don't think that's acceptable. Now, unfortunately, we get stuck in a situation where, you know, anytime that there's sort of, you know, demands for accountability on those organizations, that they throw up their hands and they say, oh, job losses, you know, economic apocalypse. We need to kind of come to a better situation where we can't be held to ransom by companies in South Africa. And I think the climate change bill and what it's attempting to do, the systems it's attempting to put into place, are going to go a long way towards that, to encourage companies to kind of get on board with what is happening. I think one of the positive things, though, is that, you know, whereas you know, corporate actors can sometimes, for instance, with taxes, they can sometimes say, we'll go to a different jurisdiction if you impose this tax on us. Well, good luck finding a jurisdiction that isn't part of the Paris Climate Accord. The whole world is committing to this process. And I think we have a real opportunity to kind of end some of that, you know, that sort of corporate blackmail, for lack of a better word. In terms of the question of whether Papia and Paya, whether we should be raising that more generally, and Madam Chair, you've raised the same sort of issue, whether you know, we should not be looking at amending Paya and Papia. I will say that we probably will go to court at some point to try to challenge the really problematic parts of the legislation. The problem is, though, is that we have to wait for a case that comes up that's appropriate for us to take to court. You know, that can take a really long time. We have no idea how a judge might ultimately rule in terms of that. And so what I would say is that when drafting this legislation, we have to legislate for the status quo as it currently is. We cannot sort of assume that those really restrictive parts of Paya and Papia will be repealed at a later stage. You know, as I've said, the Department of Forestry, Fisheries and Environment itself, the department that's going to be most subject to this bill, they have already shown a willingness to embrace automatic proactive disclosure as the standard when, you know, faced with issues that have an extreme impact on the environment and have an extreme impact on a large number of people. I think we should take their lead on that. And make sure that this is baked into the bill. You know, if someone wants to come and challenge that, at least we have one fight. We don't have to have 50,000 fights every time there's a Paya application. I hope that that's answered most of your questions. If there's anything I haven't answered, I'd be more than happy to take another stab at it. Thank you.
I think you have managed to do that. And then something that struck me as well on your presentation is when you say you represent the voiceless. Like yourself, you can access court. But you think about the ordinary South Africans that don't have that access. I think you've raised a very critical issue that I think as public representatives, we need to also consider that. But then I'll see if colleagues have could follow up. Let's allow the Mellers to first respond to the issues. But yeah. Anything you want to say, starting Mike or so?
Yeah, thank you, Chair. If I can start with Honourable Singh's queries around the just transition, and particularly around this question of employment. How does that employment come about? What are the options? I'd submit that what we first need to do is to acknowledge that the opportunities are quite wide, and we need to understand which opportunities are appropriate in different contexts. So let me use a contentious one, because it's going to come up again in another context, the issue of using gas as a transition fuel for this transition, as many countries in the world are doing. South Africa has a choice between importing gas from a very contested international market, which is all over the place and will continue to be so. It's a very volatile market. We had a decade ago the possibility of exploring for gas domestically on land through a process called fracking, which we were immediately told is absolutely impossible, is disastrous for the economy, it's disastrous for the environment. And yet what we are seeing is that fracked gas is actually the biggest source of gas that is being exported into this confused international market. If we were to drive through the Eastern Cape, the Karoo areas of the Eastern Cape and the Southern Free State, we would see desperately poor communities. We would know that there are opportunities there for exploration and perhaps for production, firstly of gas and then for gas-fired power and perhaps in the future hydrogen-fired power. But this has been obstructed systematically for over a decade by a combination of landowners in the Karoo and environmental organizations who have actually denied employment for what could be a very viable option, which has been demonstrated in a number of countries across the world. So do we look first at the jobs, or do we first look at the spectrum of opportunities that could offer us jobs through this transition process? And I think this is why it becomes so important to have objective guidance as to what are the options available to us, what are the pros and cons, and why, after we spent huge amounts of money on the biggest ever strategic environmental assessment, which was on fracking, which concluded that exploration is really necessary and we ought to go ahead with it, why are we still blocking it 4 years after the conclusion of that study? You know, we have to ask, at what point will South Africa, and particularly the South African government, take difficult decisions? And I have to use this as an example of why it's inappropriate to locate the climate strategy responsibility in the Department of Environment, which is really conflicted about these matters, because I think it's leading us to suboptimal outcomes. We wanted also to talk about Eskom and Sasol, and, you know, are they the elephants in the room? And yes, of course, they are the largest sources of CO2 in South Africa. They also happen to drive our economy through the energy contributions that they make. And it's a coal-based energy contribution, which we need to get away from. But I do believe that if we are not willing to consider how those companies with their huge technical resources can contribute to the process of the just transition, if we treat them, as I'm hearing, for instance, from Bongani, as enemies, then I think what we are in danger of doing is shooting South Africa in both feet, because those are two institutions which have the capability to assist in making the transition. And, you know, it's another example of how the regulatory framework is, I'm going to say, biased towards an environmental perspective, which quite often is polemic and is not technically informed. So I'm sure members are not fully aware that according to the IPCC, sulfur dioxide and particulate emissions have helped to screen the world from global warming to the extent of 0.5 degree over time. And one of the crises that has emerged over the last 2 decades has been, as coal-fired power stations have been cleaned up, the reduction in emissions has accelerated the rate of warming. That's all in the IPCC documents. It's uncomfortable truth, but what it does say is, why is the Department of Environmental Affairs still insisting on trying to make Eskom spend 30 billion rand on cleaning up flue gases at Medupi, which is not in one of the areas affecting many people's health? There are very few people around Medupi. Why should we spend 30 billion on cleaning up something that produces global warming if we can spend that money on new mitigation and adaptation arrangements? And you see, I'm scared that the debate is being skewed by lobby groups and frankly, incorrect information which affects policy. And that raises questions about how the PCC can function. Let me just lastly make a comment on the issue of Sasol and Eskom, and perhaps focus specifically on Sasol. On the one hand, yes, Sasol is the largest emitter of CO2 in the Southern Hemisphere, if not in the world, as a point source. However, Sasol is also perhaps the only domestic organization that will be capable of investing in green hydrogen at the scale we would need in 20 years' time to complement the other renewables that might be able to produce 40 to 50% of the energy needs that we have. If we do not support them in that venture, as we've seen, they may be able to invest abroad, they may simply reduce their size. South Africa will then be dependent on external technology and external investment and all the whims that it may bring forward. We lack a structured view of the benefits as well as the costs of having an institution like Sasol in South Africa that is, and has been for, I know to my knowledge, for at least 10 years, been looking at the opportunities for a transition, an energy transition, and which has very strong proposals for hydrogen development. But unless we mitigate the impact of single sector, single interest lobbies, and I refer here to the environmental lobby, which doesn't like gas, it doesn't like hydropower, it doesn't like all sorts of things, which can contribute to the transition, we won't make the progress that is possible. And this is why it becomes very important to mitigate the impact of single sector lobbies, and it includes the green lobby, by the way, who are in danger of diverting us from useful pathways and viable pathways that could achieve the justice, like employment, like income available for distribution, that we actually are seeking. So, Chair, with apologies, I think it is very important to understand that the distortion of the debates that we are having needs to be countered, and one hopes that the PCC can contribute to this. But to achieve that, we will have to be very careful about understanding the perspectives and the basis for those perspectives that are brought into the discussions that guide us. I think perhaps on the costings, let me hand over to my co-presenter.
Thank you. Thanks, Chairperson, honourable members. I'll try and be brief. Just to say, by the way, we presented a 16,000-word paper at the TIPS Forum recently, and so as my co-presenter is indicating, we have a lot to say on these matters, and we're concerned about many dimensions of them. To say something on the costing side in response to Honourable Singh, maybe I could respond with an example. So, and we're going to be making a submission probably on this regulatory change as well. There's been the recent decision to amend regulations to allow greater decentralized generation. And on the face of it, that's a good thing, right? We know that Eskom is suffering from capacity shortages. We know that has implications for the economy, for people's well-being, and so forth. But allowing decentralized generation has implications for Eskom's finances and municipal finances. So at this recent conference, we put the question to somebody from the representative from the presidency, and we asked, why has this not been costed? Why are regulatory changes on the table which could lead to massive financial implications for Eskom, which will then have to be absorbed by the state or by the taxpayer effectively, because we know that the government is planning to take on a lot of Eskom's debt? Why is this not being costed? I mean, it's a very basic principle. And there wasn't an answer to that question. The answer was basically, we should look into that. Now, that's a violation of those principles that I was listing earlier. It's a violation of decisions that have been taken by cabinet. principles. The National Treasury is doing training with lower government levels to cost policies and so forth. But this is not happening with one of the biggest policy changes of this decade. And so that's a huge concern. And so the first way of dealing with this is doing those costings and putting them on the table. Then a discussion can happen in the relevant fora on how those will be funded. So that's one specific example. But what's nice about it is that it is more specific than the types of things that are conceived of in this bill. So Honourable Singh was asking, the bill envisages certain functions being taken on by municipalities. How are we going to ensure that the funding follows those functions? Well, to the extent that those can be costed, they should. And then a discussion can happen in the relevant fora that decide fiscal allocations, how that's going to be dealt with. And of course, there should not be unfunded mandates. I mean, this is a principle in the Constitution. But in order to make sure there aren't unfunded mandates, we need to be looking at the costs. So I'm not going to suggest we have any easy answers, because of course the bill rightly seeks to address a range of issues which can have different costs and implications and so forth. The point is that the relevant bodies need to deal with this in the appropriate way. So that's what I would say on that. I don't have anything to say about Eskom and Sasol at this point. On the question from Honourable Bryant about vested interests, thank you for that. So we've been thinking about it in the broader policy context, but as you quite rightly note, it is important that the committee thinks about these issues. Well, let me speak for myself. I think my co-presenter agrees, but my view is that whenever individuals make submissions on these kinds of issues or to these kinds of fora, they should actually always be obliged to address potential vested interests or conflicts of interest, funding sources and so forth. On our part, for example, we can say that we are not funded by any vested interest. We do not have any vested interest. You can essentially think of us as doing this work because it's public interest related. Nobody's paying us to do this work. And unfortunately, that's rather unusual. So it's entirely appropriate to have business representatives from the photovoltaic industry, representatives from environmental groups, and so forth. It's entirely appropriate to have all those voices, and it's crucial that Parliament does hear all those voices. But there's a distinction between individuals and groups that are lobbying with particular agendas and those who purport to contribute as experts or independent individuals or institutions concerned with the broad public interest. And I think the committee needs to try and find ways of distinguishing between those kinds of inputs. Both are important. It's important to hear the side of coal producers. It's important to hear the side of renewable energy companies. It's important to hear the sides of communities, of course, and so forth. But stakeholder inputs are different to expert inputs. The representative from the PCC earlier was referring to some different expert groups. We have concerns about some of those expert groups, about where their funding is coming from and how that influences the kind of research they produce. Just to give another example, the Canadian government is funding an international sustainability institute, which is funding research in South Africa that argues against gas exploitation. The interesting thing about that is Canada is busy exploiting deeply harmful tar sands for producing hydrocarbon sources of energy. So we have a government that is not actually stopping itself from causing a great deal of environmental harm, but at the same time is funding an international group which is trying to block arguably less environmental sources of energy in South Africa. So those are the kinds of things that we're concerned about. And look, this needs to be dealt with at a larger level than just the committee. But to the extent that the committee is able to, I think paying attention to funding sources and distinguishing between the roles of the groups that are making these submissions, I think would be helpful. Has there been best practice elsewhere that's dealt with this? I'm not sure about that. I think it's a very difficult problem. And I do think that there are probably many other countries that are struggling with it as well. Thank you, Honourable Chair. I think you didn't have any questions for us, but rather comments, and we appreciate those. We're happy, of course, to engage with the committee on these and other issues in the future. Thank you.
As I said earlier, Dr. Miller and Prof. Miller, to say we are being enlightened here. We want to appreciate this. Dr. Oliver, you still here? Crispin?
I can't see him on the list, Chair.
Is there any one of you two who want to comment on what the issues that were raised in relation to your good selves?
Thank you, Chair. I think what we can say is we note the issues. The Commission does have a charter that guides the relationship and how they are engaged in the work of the Commission. But I think, Chair, it's noted what the speakers are saying, and we will return those inputs to the Commission for consideration. Thank you.
Okay, thank you.
Chair, if I may.
Oh, you want
to? Chair, if I may just make one brief comment. Mr. Muller had raised the suggestion that we were treating ESCOM and SASL as enemies. I certainly don't think that that's the impression that we want to give. It's just that we do not believe that that any company should be treated as too big to be held accountable, and that's simply what we're calling for. Also, in terms of the question around vested interests, we'd be happy to share the sort of approach that we take in terms of funding, if that's helpful to help guide, the kind of radical transparency that we practice in terms of where our funding comes from, and in terms of, how we put in place barriers to ensure that no funder has any influence over the content of what we produce or the issues that we lobby for. Thank you.
Fair enough. Fair enough. Colleagues, any follow-up? We're covered. We can move to the next two presenters. I don't see any end. Ms. Adams from the South African Human Rights Commission, are you ready?
Hi, good morning, good morning, Honorable Chair. I'm actually joined by Ms. Yuri Ramkisoon.
Where are you?
Now, I'm not presenting. There's been an amendment to the agenda, so Yuri is stepping in. Thank you.
I see, because I've been told it's you. That's why I'm calling you by name. It's okay.
Good morning, Chair. So I'm Yuri Ramkisoon. I'm from the South African Human Rights Commission. I think there was an error on the program, but I was scheduled to speak. Fadla is just our parliamentary liaison here today. And just to start with apologies from Commissioner Ntuli, who was supposed to be here to do the introduction, but she's in another meeting with the Premier and she's unable to join us at present. I'm going to switch off my camera because I'm having load shedding at the moment, so I don't want to, clog up the bandwidth. But if Fadla, Fadla could kindly flight the presentation for me, thanks. Thanks, Fadla. It's not in presentation mode. Although I'm sure colleagues can see it though. Okay, that's fine. Let me start. Fadla, if you can go to the next slide.
You're not granted sharing rights, Yuri.
Let me try sharing. Fadla, will you stop?
To save on the time, please.
Let me try. Thanks. Can you see my screen?
Not yet.
now? Chair, can you see it now?
Yes, you can proceed.
Thank you. Okay. The objective of the South African Human Rights Commission is to fulfill its responsibilities and mandate to ensure the promotion, monitoring, and protection of human rights in terms of the Constitution. Under Section 13 of the South African Commission Rights Act, the Commission may advise Parliament or any legislature on the adoption of legislation which may promote respect for human rights or a culture of human rights. So accordingly, the Commission wishes to thank the Portfolio Committee for this opportunity to make a presentation on the proposed climate change bill today. So thank you to the Chair and all committee members. On the matter of climate change, a recent UN report on climate change has indicated that carbon emissions from 2010 to 2019 have never been higher in human history, which is proof that the world is indeed on a fast track to disaster from climate change. In addition to other studies, the fifth report of the Intergovernmental Panel on Climate Change, the IPCC, has detailed the devastating impacts that climate change will have on the natural environment, ecosystems, the lives of millions of people, and the infrastructure on which people depend. This includes impacts on water, food, land, human settlements, and ultimately life. Climate change is clearly an economic, social, and environmental justice issue, particularly given that the cause of climate change came from the developed world, but it is the developing world that will bear the brunt of its impacts. Importantly, sub-Saharan Africa will be particularly hard hit with the temperature increase of over 1.5 times the rest of the world. And there will be a disproportionate impact of climate change on vulnerable groups such as women, children, and people with disabilities. In terms of general comments, we look at procedure first. Wide-reaching engagement is required on this bill, preceding which there should be a broad, clear notices of such via email, via all forms of social media, including via all forms of media, including social media and local community radio stations. Additional efforts should be made to engage specific groups such as women, the youth, and people with disabilities. Translators and sign language interpreters should be present at all engagements, which should ensure a two-way form of communication, not just the dissemination of information. Section 237 of the Constitution states that all constitutional obligations must be performed diligently and without delay. Therefore, the Commission urges the committee to expedite the finalization of this bill and all associated legislation without compromising public engagement efforts. Additionally, due to the enormity of the challenge of climate change and the need to ensure a human rights-based approach to implementation and adaptation, the Commission suggests that the bill specifically provide for the participation of the Commission in the Presidential Climate Commission as provided for in Clause 10 of the bill. General or substantive comments on the bill. The Commission commends the bill at the outset for making the distinction between natural and anthropogenic climate change, the latter of which poses a threat to humankind and the natural environment. The main and significant criticism of the bill, however, is that it's not human rights centered and not based on the founding values of the Constitution. Climate change, as other speakers have said, is first and foremost a human rights issue. It is therefore inconceivable that the bill is not framed from a human rights base and on the prerogatives of the Constitution, including the founding principles of the rights to equality, dignity, and the right to life. By not centering climate change as a human rights issue, the bill ensures that climate change remains steeped in science and remains an abstract, non-human related concept, which is the antithesis of what the bill should achieve. The bill is also not grounded in international, regional, and other domestic legislation and policies. For example, there is no mention of the National Development Plan and Sustainable Development Goals, with which the bill must work in tandem. On this slide, I have a quote by the Office of the High Commissioner on Human Rights. I won't read it in full, but it speaks to the needs and advantages of a human rights-centered approach to development and service delivery. One of the most significant difficulties facing civil society organizations and communities in the environmental field is the lack of a human rights-based approach to development and planning. This is evidenced by the lack of access to information, leading to a lack of transparency and a lack of adequate engagement with stakeholders, as other colleagues have spoken about, and as the Commission sees through its various PIA applications, complaints about PIA applications. Of particular concern are the poor levels of voluntary disclosure of information, which should ordinarily be provided proactively in the public domain. The lack of transparency and access to information limits the potential for community-based monitoring, which is particularly important for accountability. In the South African context, such controls and participation are especially important given the high levels of corruption, extreme poverty and inequality, and the less than optimum implementation and enforcement of laws. Poor or limited information flows lend significantly to decreased transparency and accountability and increased violations of the environment, to the environment and the law. Moving to education, awareness and training, the bill does speak to the enhancement of public awareness of climate change causes and the impacts of the promotion of participation and action at all levels. However, it provides no specifics on how education and awareness at all levels, particularly within communities, can be achieved. Education and awareness are not confined to humanizing climate change, but is vital to the promotion of knowledge sharing, innovation, and the development of policy which is relevant to evolving and emerging concerns. This element is therefore particularly beneficial at a local level for robust and inclusive response to many complexities and challenges posed by climate change. Education and awareness further enhances community buy-in to projects and programs. The bill also inadequately recognizes the devastating impacts that climate change will have on the people of sub-Saharan Africa, particularly those that are already impoverished. While vulnerable groups of people are specifically referred to in the principles of the bill, the disproportionate impact on groups like women, rural dwellers, people with disabilities, and the poor requires specific mention in the preamble of the bill and additional policy focus to ensure targeted interventions to assist such individuals and groups of people. The bill should also take cognizance of the fact that some people have multiple vulnerabilities, such as Black women living in rural or outlying areas of South Africa. The wording around vulnerability to the impacts of climate change is better articulated. Is better articulated in South Africa's National Climate Change Response White Paper and should be assimilated into this policy. Given the extreme urgency and commitment required to limit global warming to a level of 2 degrees Celsius, at worst case, the bill is inadequate in the following ways: at setting out a concrete and clear plan to curb emissions, setting sector-specific emission targets, and setting timeframes for the achievement of targets. In addition, the bill does not make explicit reference to the Paris Agreement to which South Africa is signatory. The Commission is aware that the bill provides for the Minister to set national greenhouse gas emissions trajectories and to determine GHG emission thresholds at an undisclosed time. But the interim national greenhouse gas emissions trajectory as outlined in Schedule 3 of the bill, is aligned with South Africa's 2015 Nationally Determined Contribution, or NDC, also known as peak, plateau, and decline. According to the Climate Action Tracker, this NDC is inadequate, which indicates that South Africa's commitment is not in line with the interpretations of a fair approach to reach 2 degrees Celsius as set out by the Paris Agreement. Given that South Africa released its revised NDC in 2021, the bill should at very least reflect this updated information as targets for 2025 and 2030, even though it is only the lower limit of this target that falls under the adequate category. South Africa is one of the top 15 greenhouse gas emitters in the world, and it needs to do more to diversify its energy generation with stringent timeframes and targets immediately. The provision for penalties is extremely limited in the bill. Given the trend of non-state actors to violate regulations, there is a clear and convincing need for a broader range of penalties, including the option for the relevant minister to revoke an operating license if an emitter exceeds carbon budgets and or fails to adhere to mitigation plans. One of the main objectives of the bill is to reduce greenhouse gas emissions. This can only be achieved if emitters are required by law to reduce their emissions and if there are consequences for failure to do so. The United Nations Environment Programme also states that carbon offset projects will never be able to curb the emissions growth while reducing overall emissions if coal-powered stations continue to be built, petrol cars continue to be bought, and our growing global population continues to consume as it does today. Therefore, carbon offsetting should not be considered a solution, but rather one small strategy in an arsenal of solutions to the global emissions problem. Local government is charged with ensuring access to basic services at a local level, including environmental management, but is beset with severe and myriad systemic challenges. Local government is a key sphere for the realization of the bill and will bear the greatest burden of the impacts from climate change. Greater emphasis on the role of local government is required in the bill, including ways in which the state will capacitate local government as a first responder to deal with the impacts of climate change. In addition, municipalities must have individually developed climate change response strategies, which will aid with the identification of gaps in resources. Climate change is not just the responsibility of the Environmental Ministry. The bill does not adequately deal with mainstreaming of climate change to ensure a concise and coordinated response strategy. Climate change strategies should not just be a perfunctory addition to department planning, but that it should be part of the core work of the public sector, and resources must be allocated to ensure that the implementation of programs and plans are undertaken without any hampering. In terms of externalities, the bill refers to the socioeconomic impacts of introducing sectoral emission targets and imposing carbon budgets, but not the socioeconomic impacts of not achieving net zero emissions. The bill should make provisions for the calculation of costs to the state and state departments, including departments like the Department of Health, Water and Sanitation, Cooperative Governance and Traditional Affairs, and Human Settlements, of not limiting greenhouse gas emissions. For example, the burden on the Department of Health due to respiratory and other non-communicable diseases. The state must begin to evaluate the costs of not reducing greenhouse gas emissions to the state and the cost in terms of human lives. While this section on one environmental system does not constitute a comment on the provisions of the bill directly, the Commission felt it would be remiss not to raise the very pertinent issue of a lack of synergy between environmental and other related legislation, which has far-reaching implications for the environment and human rights in South Africa. The Commission recognizes efforts made by the state at mainstreaming environmental and mining application processes, for example, through amendments to the National Environmental Management Act and the Minerals and Petroleum Resources Development Acts, ensuring collaboration between the relevant departments. However, challenges persist in the One Environmental System, and this is evidenced by the myriad mining-related complaints received by the Commission and civil society organizations on systemic human rights violations in mining areas and to mining communities. In its 2016 report on the national hearing on underlying socioeconomic challenges of mining-affected communities in South Africa, the Commission found that discrepant approaches in the application of environmental management laws and limited oversight of environmental management across multiple sectors were a cause for concern. Additionally, the Commission found that the Department of Mineral Resources and Energy was not the appropriate authority for granting and enforcing prospecting and mining licenses. The bill should, in addition to dealing with mainstream issues, should clearly articulate how it will operate in relation to NEMA and other relevant legislation to ensure harmony and synchronicity of legislation. Sorry, I should have changed the slide earlier. The environment is essential to human life, both current and future generations. The rights of individuals to dignity, life, and an environment that's not harmful to their health and well-being is unequivocal. However, it is important at the outset for the bill to recognize the inherent right of nature to exist. The natural environment has a right to be protected in and of itself, regardless of whether it is of use to human beings. If states can see human beings as part of a living system, as opposed to stewards of the earth, human responsibility to respect the environment from human-induced damage will come more naturally than the opposite. This is just a summary of the recommendations that the Commission made to the committee. I've covered all of them. But just to close, the Commission thanks the committee for its time and remains committed to working with the state, civil society organizations, and communities on the realization of the right to a healthy environment to ensure that the impacts of climate change on life, equality, and dignity are minimized. Thank you.
Thank you so much, Yuri. Mr. Parks? Yes, can you remove your presentation from the screen so that Mr. Parks can load this, please?
It's trying to unshare.
Yeah, Mr. Parks.
Hi, apologies, Chair. I just got momentarily kicked out. My apologies for that. Should I start?
Yes, yes.
Okay.
Yes,
no, thanks.
Welcome.
Thank you. I'm sorry if the committee secretary could just give me hosting rights again. I lost them when I accidentally got kicked out. Apologies.
Oh, okay.
Yeah, I think just for the committee secretary, just add me as a co-host.
Okay.
Chileka, are you able to just include me as a host again?
Chileka, assist.
Okay, sure, she's done it now. Thanks, Chair. Apologies for that.
Thank you.
Okay, it should be there now, Chair. Sorry, wrong one. I just missed Murphy's Law today. It's Murphy's Law today. I'm not normally this chaotic. Okay, all right, thank you. Yeah. Sorry, gremlins always come up to conspire against you when you wanted Honorable Chairperson. No, I think, good morning to honorable members and chair. So thanks for giving us space as COSATU to make our presentation. So my name is Matthew Parks from COSATU. I'm also joined by a colleague, Butamelo Molite from our head office, who is our Social Development Policy Coordinator. So we're just very pleased that we've been given a chance to raise our views as COSATU, and in particular on behalf of our affiliate unions, who organize in every sector of the economy. We organize in police sector, public servants, nurses and doctors, agricultural workers, mine workers, transport workers, every part of the economy. And of course, workers are part of communities. They feel the impact of climate change, the impact of climate change upon mine workers. Workers in the coal industry, the energy plants are significant. But of course, also we have workers, who are affected by natural disasters like the floods in KZN, pollution in Mpumalanga, etc. But also, Chair, whilst we have members our members are workers, of course, and they're fortunate to have jobs, but they also are affected by the unemployment crisis, 44% unemployment. Our members are supporting relatives who have lost jobs, who have lost wages. And we have members who have seen job losses in many industries. In the 1980s, we had 1 million jobs in the mining industry. Today, it's about 400,000 and likely to decrease further. We have many members whose jobs will be at risk as the fourth industrial revolution gathers momentum, including in the mining industry and the energy industry too. So for us, we're dealing with multiple crises. We're dealing with the crisis of climate change. We're also dealing with the crisis of unemployment. And of course, we also recognize the state has got very limited fiscal resources. So for us, it's about balancing many equally critical challenges and finding the right balance in that approach. So Chair, as COSATU, we've supported this climate change bill. We're quite pleased it's now before Parliament. We have been raising the need to table it at Parliament with the Ministry, with the Department for some time. We were a little bit disappointed the bill had been delayed, but we understood why with the change in administration after the last elections, and the need to kind of synchronize it with the carbon tax regime. But nonetheless, I think as COSATU, we believe this bill is long overdue, it's progressive, and we're urging Parliament to pass it in time before the next elections. And perhaps, Chair, I must also just say that whilst Parliament must do its due diligence, we must consider the bill as it's mandated by the Constitution, make amendments where it's relevant and necessary. But also we are very sensitive as COSATU that we are coming towards the final lap of this parliamentary term. The next elections will take place around March, June 2024, which means basically we have the remaining 3 months of this year, and we have the parliamentary year next year to process this bill. So that can easily be done, but it just means that we don't have endless amounts of time too. And I think for us, what we would want to see is the bill being passed by this term. And I think for us, it's a foundational bill. There will always be space, I think, to make further enhancements, to further strengthen it after the elections, etc. So we're just making the point, we don't want to see this term pass without this bill being passed into law, without the president signing it, etc. But I think, Chair, for us as COSATU, it's a badly needed intervention, and if we think it's going to help to coordinate South Africa's very laggard efforts to tackle climate change. We're very good at lip service, but when it comes to practical action, I think we're all found very wanting. We're also quite pleased that we think it'll help to ensure that national, provincial, local government and the key state-owned enterprises will also develop appropriate climate change targets. Chair, we do believe as COSATU that it does seek to address the correct balance between saving the environment, protecting the health of society and workers, and also saving jobs. So we don't think either of these critical objectives should be compromised. In fact, they're actually complementary. But we recognize, Chair, this is a very difficult balance. It is a difficult task for this committee as well, to be fair, to achieve this right balance. But we think the bill does do that to a large extent, and we think it does actually try to ensure the environment, lives, and jobs are saved. As COSATU Chair, we had participated in quite extensive engagements in 2018 and 2020 on the bill at NEDLAC. And we do want to appreciate the very open and constructive and progressive approach from our colleagues in that engagements, in particular from the department, but I think even from some other colleagues from business, etc., in terms of how do we address the concerns of workers, which is the issues that we obviously had to raise. So in terms of the definition section, Chair, we support the definition provided for in the bill, and in particular the emphasis provided on a just transition. And this is key because the transition is occurring, whether we like it or not. So it's our task collectively, be it as government, labor, political parties, parliament, business, etc., to make sure that transition is a just one. It must take into account the needs of workers, of vulnerable persons, of communities who are at risk. We cannot afford to simply leave them behind or simply assume that the vagaries of the market will attend to it, because it won't. The market must make profit. It's not about ensuring a just transition. In terms of the objects of the bill, Honourable Chair, we do want to support these progressive objectives in the bill. We had discussed them extensively. We think they provide a clear mandate on the need to tackle the climate change, to protect the environment, to provide for a just transition and to nurture economic development, to have clear climate change plans and strategies, and to ensure that the inheritance of future generations of our kids, our grandchildren, etc., is protected. We do want to support the principles of the bill, and again, we had discussed them extensively at NEDLAC, and I think we want to welcome the focus on international equity, which I think is quite critical. The issue, again, of a just transition, the protection and the accommodation of workers and vulnerable persons and communities. We want to support the cautious developmental approach, and again, that all of our actions must be based on science. I think we've seen with the vaccine discussions last year, Chair, that not everybody is embracing science. So I think for us, let us make sure all our actions are guided by science, not guided by slogans. Chair, we think the bill provides, so the principles provide for an integrated government and society-wide response, which is critical, because government cannot do everything on its own. And in particular, there's a key role for business to play as well, industries, manufacturing, ESCOM, etc. We welcome the application of the bill, and we think it's key that all spheres of government, from national to provincial to local and to SOEs, are allocated very clear responsibilities and tasks and timeframes, and these have to be binding. If we're going to take a voluntary approach, then we're going to fail at such a critical mandate. In terms of the alignment of the policies, again, we support them, and we think climate change does require a very coherent national response if we're to tackle it. I think we want to welcome the roles provided for in the bill for business and for labor and civil society to make inputs in these government processes, the development of strategies and plans. And I think for us, it's really critical to have maximum input and ownership if we're going to ensure the successful implementation, because it's not just about this government. You may not like it because you don't vote for the ANC or whatever it might be, or a future government, but this is about the entire society. So we all need to contribute and to own it. On the provincial and municipal climate change forums, we think these are quite critical. We welcome the provisions. We think these will be central to helping to ensure national plans and strategies are successfully implemented, and that provincial municipalities must play the full role. And that's a huge task, given we have about, I think, 259 municipalities, some of which are quite dysfunctional when you look at the AG reports. But again, this is not going to work if you don't have provinces and municipalities on board. So we think the space provided for autonomous provincial municipal plans, but guided by the bill, will help ensure that plans reflect local context, which obviously will vary. The conditions in the coal belt of Mpumalanga will vary significantly from those affected by floods, like in KZN, or those affected by desertification in the Karoo or in water-scarce areas. We think the clear timeframes will also help ensure that these provincial and local governments, institutions are held accountable for the implementation by national government and by society. We need to make sure that we capacitate the state and we don't leave it with its hands tied behind its back. On the Presidential Climate Change Commission, I think we want to welcome the provisions for the PECC. Its establishment at a presidential level will help provide it with the necessary political authority to ensure success. We support the roles allocated to it, in particular its monitoring and evaluation mandate. These provisions for organized business and labor and civil society will help ensure the public at large supports its critical work, we hope, and that, of course, key stakeholders also contribute towards its implementation. In terms of the national adaptation objectives and strategies and plans, I think as COSATU we want to welcome these. We support the provisions for greenhouse gas emissions trajectory, the list, the inventory, as well as to stipulate what constitute greenhouse gases and the contributing activities to these. And we think the provisions requiring action to reduce these are quite important. And this level of detail we do think will help to ensure the national plans and strategies have the necessary scientific foundation in detail to tackle climate change. On the sector adaptation and targets and plans, again, we support these. We think these are also quite helpful given the varying impact climate change has on differing sectors. We hope it's going to empower government to work with stakeholders to develop relevant sectoral approaches, because these are going to vary significantly. If we look at mining versus agriculture, if we look at energy versus transport, but also we have to be quite comprehensive to look at how do we build houses, how do we manufacture clothing, how can we adapt textiles, etc., because it's going to change every fabric of our life as we know it. On the carbon budgets, Chair, I think we do welcome the provisions for it, and the work that is done by DEF and by Treasury to help ensure synergy between these and the carbon tax, because obviously we can't have them not being synchronized. We hope these will be a necessary carrot and stick approach to help industry move towards less polluting practices. But again, this is quite critical, because if we're going to continue to enjoy access to key trading partners in the European Union, most likely the United States later, etc., and other countries, then we need to make sure that industry begins to transition and does so in a way which doesn't weaken it. And again, but recognizing the reality, if we don't do so, we're going to lose key trading partners. And this is the reality. We're seeing it already happening quite soon. And if we don't move with speed, it will become a real issue for us if we want to avoid disrupting these trade routes, etc. Chair, around the public participation provisions, we know you always have to get a bit of a balance to make sure there's inclusivity, but also to make sure that things can move along as well at the right stage. So we want to welcome the provisions providing for it on the various regulatory adjustments, including those by the Minister. We hope these will help give stakeholders the space to give inputs and ensure the right balances are found. But of course, I think as some of the other early presenters mentioned earlier, it's critical that these are accompanied by the necessary public education and engagements, as these are quite technical matters. If you don't do this, then what's going to happen is that it'll simply be a process left to experts from academia, from NGOs, from businesses, etc. We really need to make sure that the average person on the ground in Witbank, in Tabazimbi, etc., does have a space to make their views heard, because they're the ones who feel the real brunt of climate change. In terms of the offences, Chair, I think we want to welcome provisions providing for sanctions. These are necessary to ensure compliance. It can't be a simply voluntary approach. And I think we want to welcome particular provisions providing for penalties for failure to implement greenhouse gas mitigation plans. That's critical if we want to make sure these plans have teeth. In terms of Schedules 1 and 2, we do want to support the inclusion of these key departments under the sector emission targets under Schedule 1, as well as the key departments and entities responsible for sector adaptation, strategies and plans under Schedule 2. So in conclusion, Chair, I think I want to say as COSATU, this climate change, but we believe it's a welcome and it's a long overdue intervention. We believe it is badly needed if we are to tackle one of the greatest existential threats, as you said, Chair, to humanity, to the environment, and to the planet. We are hopeful that it will help to compel government at all levels, not just national, and the entities, because they are critical as well, like ESCOM and Transnet, etc., and as well as business, to put in place the necessary assessments, plans, and strategies. We think it provides a clarion call, a clear one, for all of us to work together to save the environment for all of our needs. We think, Chair, it does help provide a correct balance with the needs to protect workers and their jobs, their families, to protect vulnerable persons and communities. We cannot afford to create ghost towns or ghost communities. We think it does recognize our real developmental and economic challenges. We believe it does provide an inclusive approach that gives space for organized labor, for business, for civil society to play their roles and to help guide the national response. And that's going to be critical if we're going to win this battle. So I think in the end, Chair, we support as COSATU this climate change bill and urge a speedy passage by Parliament. But having said that, Chair, I think listening to the colleagues who spoke earlier today, I think all colleagues have raised very valuable points. Some points, some proposals they have made, which we have not made. it might help to enrich the bill, strengthen it further, and we will support any provision which is going to strengthen the bill further to enrich it. Some proposals might be better off in regulations or departmental policies or interventions, and that's also positive. But I think, Chair, we just want to see in the end that we defend this bill, we strengthen it, and we make sure it's passed by this Parliament and it comes into effect. So I think that's it from our side as COSATU Chair, and hope that I stuck to the time frame. And yeah, I hope we assist the committee with the important engagements. Thanks very much, Honourable Chair.
You've done well. Thank you so much. Managed to cover almost everything. Okay, colleagues, those are the two presentations from both the Human Rights Commission and COSATU. Any takers? Any takers? I see Honorable Singh's hand, it's up. Honorable Singh.
Thank you very much, Chairperson. I don't know why I'm the first one all the time, but I hope other colleagues will come in as well. But thank you again for the two very valuable presentations. I just have one question for each that will enrich our thinking as we move forward. With regards to the Human Rights Commission, I think one of the things they've said, and I want to quote, the bill is not grounded in international, regional, and other domestic legislation, policies, and programs, close quote. Now, and there are a lot of other challenges or problems that they have identified with the draft bill. Are there suggestions that they would like to make to the committee in terms of specific clauses being amended or added, like some of the other presenters have made? So that's my question to them. But I agree with them that the bill has to be founded in human rights, etc. With COSATU, thank you, Matthew, for your presentation. And I think you had an advantage because you'll have participated in the NEDLAC process. I would like to know the practical implementation of just transition in the energy sector as we move to cleaner energy methods. What would a practical example of just transition be in terms of the thousands of people that belong to your union and are people that are employed in the current energy sector?
Thank you so much, Honorable Singh. You seem to be the only one who wanted to comment on this. Let me then maybe join you as well. Mine is going to the Human Rights Commission. I would like to get their response. The issue here, colleagues, all our environmental management laws, including the climate change bill, they all derive from the Constitution, especially Section 24. When we talk about climate change interventions such as mitigation and adaptation, we also do so from a human-centered perspective. Then I want to understand from the Human Rights Commission as to how would the inclusion of human rights in the preamble of the bill affect the bill differently. Mr. Parks, you seem to be the only presenter who appears to support this bill wholeheartedly. But then I just want to hear your comment also on what the Presidential Commission has presented, especially the issue when it comes considering that the country's coal sector has got about 92,000 direct employees with earnings of around 22 billion. And that it has approximately 129 billion in sales in 2017, which contributes to 28% of the country's total mineral sales, plus or minus 170,000 jobs. Their indirect jobs are created by the coal sector. And then if you have gone, when you listen to the commission, when they say there will be net positive impact when transitioning to greener economy, then I want to hear your view as to where will be the replacement of these jobs and economic injections come from, particularly when we are already at 35% unemployment. It's not your presentation, I'm just interested in hearing your view to that effect as well. And then I think we want to then appreciate your recommendation, Mr. Parks, to say you want this bill as early as yesterday, and that's also it's much appreciated. Over to you. We'll start with the Human Rights Commission, and then it will be COSAT. Human Rights Commission.
Thank you, Chair. Thank you, Honourable Naren Singh, for your question. The Commission did not make a submission on specific clauses to the bill. Actually, let me just start by saying, Chair, that the Commission supports the bill. This bill is an extremely important piece of legislation, and I don't think that our criticisms mean that the bill is not supported. I think our criticisms mean that the bill needs to be tweaked and implemented. We support it wholeheartedly. We did not make suggestions in terms of specific clauses for various reasons. The Commission wanted to provide more of a strategic comment on the bill. And we've been doing a lot of work at local government, and we wanted to focus, and this is particularly after the riots in KwaZulu-Natal and Gauteng and the floods in KwaZulu-Natal. And much of the focus of our submission emanated from that work that the Commission was doing and from Commissioners' findings in relation to those. So it was more of a strategic submission, and we are aware that our civil society partners like Centre for Environmental Rights, for example, did make specific recommendations on wording of the bill. So that would be our comment on that. In terms of whether or not mentioning human rights in the bill will make a difference, I think that indirectly it will make a difference because it is first and foremost a human rights issue. It will make a difference in the way in which communities view the bill, the way in which we can couch human rights issues when we explain the bill to communities, when our stakeholders disseminate information on the bill. But it also affects who deals with violations of the bill. So, for example, if we get a complaint in relation to violations on the legislation once it's passed, it gives us more of a mandate from a human rights-based perspective to deal with such violations via our complaints mechanisms. So it makes all the difference, Chair. Thanks.
But I should think that strategic comment and intervention becomes key because you don't just raise issues, then don't provide solutions. Can we hear COSAT?
Yeah. No, thanks, Chair, and thanks to the honourable members. Look, Chair, all legislation is a balancing act. We have to balance the interests of, which are often contradictory, often competing, and try to find the best or the least worst options. So they're never going to be perfect. Chair, they say that a camel is a horse produced by a committee. So we appreciate that the bill will not be perfect, but we think it provides a decent overall framework. To Honourable Singh's question, I think it would be in compliance with international requirements. And I think if we don't proceed with it, we'll actually find ourselves in violation of international compliance requirements, be it the COP26 processes, be it the carbon tax regime, the SDGs of the United Nations, etc. And of course, environmental issues are human rights issues, as is the right to earn a living, the right to have decent health, etc. I think, but all of these issues are complementary. We can't afford to pick and choose. And unfortunately, fate has given us many tasks, many crises. We don't have the luxury of saying which one we're going to deal with or not deal with. We have to deal with all of them. So, Chair, as Honourable Singh has mentioned, we had extensive engagement as COSATU with the department and our colleagues in business at NEDLIC on this thing over 2 processes. And I think we did feel the department really had worked closely with us. They didn't just dismiss our concerns around jobs, the impact on communities, the impact of just transition, the issues of international equity. They had actually addressed our concerns. So that's why we don't have any specific proposed amendments, but we felt we needed to indicate as COSATU our support for this bill. Not to dismiss other parties' concerns, and they have the rights to those concerns, but I think from our side as COSATU, we think this is a good step forward. It's a good progressive bill. We think it's a foundational bill towards dealing with one of the biggest crises of our lifetimes. But I think also to ensure that we build a capacitated developmental state, which has very clear legal mandates around protecting the environment, developing society, but also protecting vulnerable communities, protecting jobs, etc. We have to find the right balance. Chair, I think Honourable Singh's question about the practical implementation, which is a key question. How do you practically move towards a just energy transition? And it's good that Dr. Olver is here and the colleagues from P4C. So as COSATU, we've been concerned about this for quite some time. Our unions like NUM, previously NUMSA, etc., have long been concerned about the issue of impact. The impact upon coal workers' health is horrendous. I think we all know about stories about mine workers who retire in the mid-40s and they die a few years later from shocking pollution to the lungs, etc. So we had developed and had been adopted a NEDLAC and ESCOM social compact where we tried to look at many issues, both the generation crisis, maintenance challenges, but also just transition. And I think for us, the kind of key parts to a just energy transition is about our existing ESCOM power stations. We all know the generation crisis. Some of them are very old, like Komati, Hendrina, Grootvlei, etc. The built 1950s and so forth. We've said option A is let's see if we can extend the lifespan of some of these power stations. If we can't, can we convert them to alternative, cleaner forms of energy? And if you can't even do that, can we look at some additional alternative economic activity, like building a solar panel manufacturing plant at the site? I think the point is to make sure those workers, the 271 workers at Komati, etc., the workers in the value chain, those host communities, they must have some jobs. It's a difficult one because you might get paid at ESCOM 200,000 Rand a year, for example. But if you work in a factory, it might be half of that. So you also need to compare the value, the quality of the jobs, etc. I think the point is to make sure that we don't just provide lip service, because we're very good at lip service, but to do the granular detail that I think Honourable Singh is talking about. So if we have these workers at risk at Komati or Grootvlei, can we invest in a skills program? Can we tap into money from the CETA or the UIF, which has got funds for these kind of activities? Make sure we reskill these workers and make sure that we walk them across the road or help to redeploy them to a new job. We've said, for example, if there's a surplus of such jobs or there's jobs at risk at ESCOM power stations, can we look at redeploying them to municipal electricity departments where there is a real skills shortage? So we think on the IPPs, one of the fundamental things we've been missing is that we do not attach a social contract to it. And there's a really missed opportunity. We should be saying to the IPPs, if you want to exist and we recognize the reality that you exist, can you make it a requirement that you prioritize the employment of ex-mine workers, electricity workers, their spouses, their widows, their family, to help to transition these workers? Can we look at making sure that the materials, the cement, the solar panels, the wind turbines that they utilize are locally produced? Because again, we need to address many crises at once. We should also be looking, Chair, to say, how do we support community and worker-owned generation capacity? Can we in these IPBs say that there must be a component of community ownership, of worker ownership, etc., because that's going to help to uplift people and bring a sense of ownership. We think, Chair, the other critical part about it is around manufacturing. We've had solar panel factories in South Africa, in Cape Town, in Stellenbosch, I think in Durban, etc. Many of them have closed because we've not prioritized local procurement. So that's something we need to really prioritize. There is a renewable energy master plan, but it needs to be given more support and assistance. But we think there's huge opportunities around solar panels, wind turbines, etc. Chair, just to give you a size of the impact. In Dar, you have 2 solar panel farms, power stations. One of them has 167,000 solar panels. So there's a huge opportunity to create a local manufacturing industry and create additional jobs. But we're very slow around actual implementation. Chair, we're also very fortunate in South Africa to have a huge car manufacturing industry. We produce about, I think, 380,000 cars a year. We're going to lose that industry if we don't begin to transition it to electric vehicles. And it's not being alarmist, and one should be alarmist. Australia lost the car industry because it didn't move with time. We're seeing we could lose it to Kenya, to Morocco, to Nigeria, to other places if we don't begin to transition it. And in fact, we'll lose our export destinations for these cars that we produce to Europe if we don't begin to move it to electric vehicles. And you've seen many critical companies like Volvo, Renault, VW, all moving towards electric vehicles. That's an industry we just simply cannot afford to lose. But again, if we're talking about sustaining Eskom in terms of the mass demand base, then the vehicles, electric vehicles, will be that demand base because many mines, shopping centers, homes, buildings will go off grid. It's inevitable. But an electric vehicle industry for our 12 million plus vehicles will help to sustain it. But yeah, I mean, also the just transition is not just about energy, it's about agriculture, the irrigation, how we plant, etc. It's about how we manage and consume water, about our transport, about manufacturing, about health, etc., housing. It's about our efforts to manage desertification, etc. I think, Chair, just to your question, Honourable Chairperson. So, I mean, look, as COSATU, we've seen the difficulties of passing bills in Parliament. It takes at least about 5 years for a bill to move from Pretoria to Cape Town, back to the presidency, etc. It takes at least a year for Parliament to pass a bill. We saw in the last elections, the last term of Parliament, about 19 bills wouldn't pass before the election because Parliament just simply ran out of time. So I think that's why we're a little bit cautious, raising the concern that whilst we might want to amend the bill to strengthen it, etc., not to weaken it, let's also just be mindful of the time pressures, because we would not want to see this elections pass without such a good bill being put in law, because if we don't do that, it could be 5-10 years to get another such bill. Chair, then just lastly to the point raised by the P4C around the coal sector, no, we would agree with that. We have about 72, 92, 100,000 jobs on the sector, depending on how you take it. We think there's a need for a mixed energy mix. But the reality is, whether we like coal or we don't like coal, it is the current base of our energy system, 70%, etc. We know that we will be transitioning to, renewable energy, less carbon intensive and so forth. But for the time being, we have it. I think, Vice Chair, what's the critical thing is about managing the transition, because coal is critical towards the energy mix, to these jobs, to these communities, to our exports. We need to give space for renewable energy to grow. And I think as people see jobs being created in renewable energy, and the estimates are that you could create about 300,000 to 400,000 jobs there, I think the point is, let's see those jobs happening, and that's going to make it easier politically and society-wide to move towards a just transition. Because right now, workers are scared, they're panicking, that we have an unemployment rate of 44%. They've seen we've lost 600,000 jobs in the mining sector. They've seen a previous chair of Eskom and a previous minister of finance saying, well, we need to retrench about 17 or 20,000 workers at Eskom. So they panic. And I think what will reassure workers and communities that they begin to see the benefits of a just transition. They see jobs in Witbank, in Middelburg, etc., and Tabazimbi. That will give workers a sense of comfort, because change is scary. But I think when people can see the positive things, that will help to mobilize society behind it. So I hope I've answered the questions, Chair. And yeah, thanks to members for the time. Thank you, Chair.
Thank you so much for those valuable inputs to all the presenters since we started this morning. Without wasting much, Brendan, your hand is up.
Madam Chair, may we just resurface this question of process on what criteria were used to select the parties that came to today, and the the hearings in the rest of September. I mean, we're aware that thousands of comments came in, and we've looked at some of them via the Dear South Africa site, and many of them are kind of unsubstantiated one-liners. But we know that many of civil society actors, for example, have put in very valuable comments and don't seem to have been invited. So perhaps just clarity on the criteria used there, and maybe to get a sense of the committee's intentions with public hearings going forward. Thank you.
I've indicated that we've not yet perused all of them, given the number in my opening remarks. And as and when we go through all the submissions, we'll then call each and everyone to come. Like I'm saying, these are ongoing, but we just felt as a committee, let's start to engage. For those who have asked, because there are those who have asked to make public, to make this presentation. So whoever has requested that, will definitely give them time to do that, to make oral submissions. So basically that's it. Like you see, if you check our program, we're scheduling this, we're trying to push this work. Concurrently, we've got a bill also on the other end, the Veld and Forest Fire Bill. But we said in the meantime, let's squeeze ourselves to start to hear those that have made the request to make oral submission. That's what we're doing here now. So we'll definitely not exclude people, but we will allow the team to also help us isolate those that are straightforward. That's why we had balance today. We brought those that are against and those that are for, so that we have the both sides of the story. So don't worry about any other thing to say we are selective. We're not that. We're parliament. It's our responsibility to listen to everybody. But sometimes based on the submission, we'll have to take decision, because we also need to consider but we won't exclude, and don't be worried if we think there's any political. We are a multi-party committee. And then I think everybody is well represented in that forum. So we can deal with it that way. So that's basically it. Don't be afraid of anything. We're on course. Honorable Brian, you want to make a follow-up?
No, Chair, I just want to back you up on what you've just said. I think we had a very diverse range of presentations today. I don't think we could argue at all that it was uniform in terms of the opinions expressed. So let's hope that continues going forward, and we just make sure that we get everybody's voices represented. Thank you.
Thanks. Yeah, please, thank you for sharing the statements that I have. Thank you so much. Then, Honorable Mdise, can you then deal with the way forward? It will also address Brandon's concern as well. Yes, we have another item to process before we go to lunch and Parliament later. Honorable Mdise.
Chairperson, thank you very much. Greetings to all the presenters. I want to take this opportunity to thank all of them and their respective organizations for enriching the public hearing process. We are still at the initial stages of engaging the public inputs, which are more than 13,000 submissions that we have already received, as you indicated. And some of those inputs are quite comprehensive and are all equally important, irrespective of whether it is a single line input or whether it is a mini thesis. All of them are equally important. Many complementary and opposing views have been expressed and will need to be considered, and all of them respected as we go through the process of this bill, because it is our intention to get and reach balanced views. Chair, the climate change mitigation and adaptation are beyond the capacity of government. Thus, they require organized formations, businesses, all members of society to play an active role in moving the country to a greener and more inclusive economy and society. We should not have women, people living with disabilities, youth, and other socioeconomic classes left behind. The climate change discussions in their own nature are very complex, and they need a careful and balanced approach to mitigate unintended consequences. At the same time, climate change impacts are what we are already experiencing, and they demand agent coordinated and direct action plan, particularly in rural and high-risk areas of the country. Be it extreme weather events such as droughts, such as floods, heat waves, and so on, or ocean acidification and the rising sea levels. So this is no longer a discussion whether we contributed more or less greenhouse gases. But the reality that we are all faced with is that we have to act and get more climate-friendly technologies that will help us address both climate challenges and our stubborn triple challenges of poverty, inequality, and unemployment. We must take this opportunity on behalf of the committee, Honorable Chairperson, to appreciate the inputs that have been made in today's presentations, and most are a call to action to achieve environmental justice, to achieve economic development and social justice. And ultimately, they spoke fundamentally to human rights. We have noted some of the sentiments that there should be a reference to the Paris Agreement. There should be reference to stiffer penalties. We need to have clear timeframes and realistic costing and funding in the bill, and more provisions or mechanisms to improve transparency, disclosure, and access to information. Those are some of the issues that came across very strong today. There is a clear need for further engagements and consultations, as you have just alluded to, on the bill to ensure that proper housing of the Climate Change Commission is established. This needs to be coupled with those budgets to enable the revised transition through education, through awareness campaigns, and training of our people who are all involved in this value chain. Now, there will certainly be a need for capacity building at provincial and municipal levels. All of that needs to be coupled with the funding and probably additional mandates, as suggested by some of the presentations that we have already interfaced with today, and probably that we are still going to interface with as we go forward. Now, on behalf of the committee, I want to thank everyone for being here. Thank you very much for making inputs today. They are truly appreciated. Your passion for building a sustainable, secure, and prosperous and just South Africa. We are still going to have more of these discussions to have more clear and realistic answers. But once again, thank you very much. These inputs are valuable, and we will be part of the ongoing discussions on the bill. This committee is still going to hold more public hearings online and in person. We are still going to visit some of the provinces to get public input, which is an obligation as prescribed by the Constitution. We will have to fulfill it as a committee. So, as mentioned earlier, this is the beginning of the process. It's a pity that our plate is a bit full. We are running a concurrent process with the National Veld and Fire Amendment for National Veld and Forest Amendment Bill, but none of these bills is going to be taken for granted and prioritizing one over the other. We're trying as much as possible to give them the same priority status that they deserve. With all of that being said, Chair, on behalf of the Portfolio Committee, thank you very much.
Thank you. Can we release all the people, the presenters, and whoever came solely for this first agenda item?
Thank you, Chair.
Yes, we do. Thank you so much. You can leave quietly. We're still continuing with the committee business. Can I then hand over to Deputy Minister Sochu? Too late. We are dealing with the briefing by the Working for Fire program following the National Veld and the Fire Amendment Bill, including by the department on the Working for Fire program following the National Veld and Forest Fire Amendment Bill public hearings, including reasons for cancellation for tenders for natural resource management programs and the way forward for the program consent is briefing by the department.
Thank you very much, Chairperson, and good day to all members of Parliament. Chairperson, firstly, let me take this opportunity and congratulate you for bringing together all the interested groups under one roof for the purpose of us getting more information with regard to the processes towards the climate change bill. This was indeed excellent, and most of the views that were raised here, we have noted them, and I believe that some will be very much valuable for all of us, that is Parliament together with the department. Further, I'm not going to measure.
My omission should have allowed you to say these things there so that even the stakeholders could have heard what you're saying. Next time, it's my omission. Sorry, apology. Proceed.
Thank you, Chairperson. No, I would like just to say that everything that I have noted that I thought I would raise with the team that was here, Honorable Modise has already then raised most of those issues. I'm not going to waste any time on that one. But from ourselves as a department, with regard to the subject matter, which is on your agenda for today, we have the DG Nomfundo Chabalala, accompanied by the DDGs responsible for the environmental programs and the DDG responsible for forest management in the department. They will take the portfolio committee through with regard to the information that has been indicated to the department. That is what you needed today. And then we'll be guided by yourself then with regard to more clarities and the questions. That's all from us through yourself, Honorable Chair. Can I then give over to our DG, Nomfundo Chabalala? Thanks to yourself.
Thank you very much, DM. Good afternoon to the Honorable Chair and Honorable members in the meeting. We have the presentation as requested by the committee, clarifying the issues that were raised by the committee. I'm going to request the DDG of Environmental Programs to then take the committee through the presentation, as it is the branch that is responsible for implementation of these programs. With your permission, Chair, let me hand over to the DDG to take the committee through the presentation. Thank you.
Is the DDG in the meeting?
Yes, Chair.
Good afternoon, Chair, honorable members, Deputy Minister, and DG and colleagues. I am in the meeting. I am just trying to share my screen on the presentation that I'm going to be making.
This is what we wanted you to do because it went quiet.
Apologies, Chair. Am I audible now?
Yes.
Okay. As the DG and the Deputy Minister and the DG indicated, I will be leading the briefing to the Portfolio Committee on the Working on Fire program and also the Natural Resources Management programs in line with the request for information that we had received. In terms of the presentation itself, I'll just highlight very briefly on the purpose of the environmental programs and also update the committee in relation to the Working on Fire program. So it's the overview, but also in terms of the arrangements that we have to make sure that the program is operational. And then also, I will then take the committee through the Natural Resources Management portfolio in terms of the previous tender. As we've previously shared with this committee, the branch, Environmental Programs branch, is mainly responsible to ensure the implementation of the department's mandate through applying the expanded public works program principles. So our main deliverables talk to job creation, training of our participants, and also deliverables that relate to the environment in terms of hectares cleared, biodiversity infrastructure constructed, and other aspects as well. What is also key from a branch perspective, and as mandated by the department, is that we are part of the broader public employment programs initiative of government. In line with the request for information, I would just like to highlight that one of the programs that we have within the environmental programs portfolio is the Working on Fire program. The program, since its inception, it aims to enhance the sustainability and protection of life, the livelihoods, ecosystem services, the natural processes in order to contribute to economic empowerment, skills development, social equity, and accelerated service delivery through integrated fire management. And similar to or in alignment with the main outputs of our environmental programs portfolio, through the Working on Fire programs, we focus on job creation, prevention and control of wildfires, implementation of integrated fire management, and also reducing the risk of high biomass loads. The program operates across all 9 provinces, and we have working relationships with a range of partners at the 3 spheres of government. And also through how the program implements the integrated fire management interventions, we address prevention, management, and control of wildland fires so as to address or enhance the sustainability and protection of life, property, and the environment. Through the program, the mode of operation, it utilizes both ground-based and also aerial firefighting support capacity, and is dependent on the deployment of ground firefighting crews and resources for wildland fires. And in terms of the current arrangements, because I think there was an issue in terms of the request on the cancellation of tenders, that as part of the department's response and commitment to make sure that there's continuity of the working on fire services, and also protect or prevent job losses in terms of, particularly from an EPWP perspective. When the existing contract was and has been extended until 5 January 2023, that was based on an approval from National Treasury. And with that approval, we were then able to make sure that the 5,300 participants, in terms of the target, we are able to make sure that they are continued to be employed and participating in this EPWP-based program, that they continue to receive both accredited and non-accredited training, that its services in terms of manual fuel load reduction, the fire belts, prescribed burning and awareness and communication, those are maintained with aerial support and also responding to disaster fires. At some point, the department had initially advertised with an intention to appoint a service provider for the Working on Fire program. And that previous advert was, we refer to it as it was advertised as tender E1581. We followed a competitive process to appoint a service provider as indicated, and the intended period was and is still for 5 years, even in the new tender that we've advertised. We had completed the evaluation and identified a preferred bidder, but through further engagement, it was found that the bid was non-responsive, and the non-responsiveness was due to a range of factors, including inclusion of VAT on the bid price, subcontracting, and prepayment requirements. I do need to highlight that had the department proceeded with the appointment, there was no way the department would have been able to proceed with the appointment of a bid that was deemed non-responsive, because that would have been irregular. It would have been an irregular appointment leading to irregular expenditure. So based on engagements with Treasury and also Council, in deeming the bid non-responsive, we then, the tender was cancelled. Based on advices as highlighted in the slide. And following the cancellation of the tender, as indicated earlier, the department then engaged its current service provider and was able to secure a contract until 5 January 2023, as I indicated, just to make sure that there's continuity in the services of the Working on Fire program, but also protecting the losses in terms of the jobs that we could have had with regard particularly to the EPWP participants. So a new tender was advertised for the Working on Fire program, still on a 5-year contract, 5-year arrangement. And it was advertised on the 23rd of August, and we've already had a briefing session with prospective bidders, and a number of questions were raised, issues for clarity that we are attending to as the department, and we still aim to conclude the award in this calendar year, so that we have enough time to be able to proceed with the closure of the current contract that ends at 5 January 2023. We are aware and have been participating with our forestry colleagues in terms of the hearings, the public hearings related to the Veld and Forest Fire Amendment Bill. And it is also critical for us to highlight that, yes, we've attended, as we have attended the public hearings, there have been matters that we've identified as relating directly to the WAF program. And such include the aerial resources, concerns being raised that the aerial resources were mainly available to FPA members. And as such, the new tender allows for allocation of some flying hours for community areas. So that's us as a department trying to be responsive in terms of also making sure that the services of the Working on Fire program as a government-funded interventions are accessible to as many people as possible. So the amendment in terms of the new tender talks to one of the amendments talks to the allocation of some flying hours for community areas, and also the new tender in terms of its terms of reference recognizes support for all the FPAs, the registered FPAs. And that support aligns with the department's strategy in terms of supporting the FPAs, which is led by our forestry branch. Also, in terms of the issues around additional firefighting resources across the country, we recognize that despite the limited amount of funding and that is currently available, we are looking at ways and means to refine the non-firefighting operations, which will also then assist in terms of us unlocking an opportunity to increase the number of firefighters in terms of the EPWP participants. Issues around the support for structural firefighting for us is just from a context or a perspective of the Working on Fire program. This is not part of the mandate, as its focus is on field and forest fires. The issue around the firefighting wages, it's under consideration. It's a matter that we have prioritized in terms of the new tender to make sure that at least the wages offered to the EPWP participants are aligned accordingly to what and is within the allowable scope of payment of wages in terms of EPWP. The other aspect that we are requested to, or we were requested to respond to, was on or is on the natural resources management tender. Similarly, here the department had, I think it was in 2020, 2021, had advertised a tender for the appointment of service providers for the natural resources management portfolio. The natural resources management portfolio mainly consists of it's working for water, working for wetlands, and working for ecosystems, but mainly the key drivers in that program, it's mainly working for water and working for wetlands. So the previous tender, which is E1590, that was advertised, had 14 categories for the appointment of service providers across the 9 provinces. And similarly, it was cancelled due to non-responsiveness of the bids that we received. And as such, the department had to initiate, and we've initiated a process to appoint service providers for the natural resources management portfolio, with an intention to conclude such a process before the end of the financial year, so before 31 March 2023. However, it is also key to highlight that while that process is unfolding, following the cancellation and also embarking on a new process, the department, we received approval to extend contracts that were existing at that point in terms of budget and time variation, but also single source appointments to enable us to make sure that we are able to continue with operations in terms of the clearing of invasive alien species, the rehabilitation of wetlands in a manner that creates jobs and affords our participants training opportunities. As a department, we are also, within the scope of natural resources management, have had to, in strengthening our collaboration and cooperation with our entities, allocate some of the work to some of the scope of work in terms of the natural resources management to our entities. And such also includes working for wetlands from an infrastructure perspective, as there is an infrastructure element in terms of the wetlands portfolio, and also are in the process of engaging with other national departments and provincial departments that we were looking at in terms of trying to fast track us being able to allocate the allocated budget or allocate the budget and make sure that in terms of the APP, we are then able to have contracts in place that enable us to deliver. But I do just want to, on the slide, highlight that we have extended contracts on budget and time variation, and also single source appointments just to be able to maintain the operations on the ground. And these measures are intended to then assist us and make sure that by the time the current financial year ends, we would have been able to conclude the appointment of service providers for the natural resources management portfolio on a 5-year basis to operate and implement projects across the 9 provinces. What is also key, based on lessons that we learned with how the department had framed the terms of reference for E1590 to how it is being approached at this point, or our thinking in terms of how we are approaching it at this point is to simplify the tender and have fewer categories. And those categories from 5 moving to 17, and highlighting that the different aspects, mainly tender 1, tender 2, and tender 3, it's mainly similar. It's a similar scope of work with differences in terms of the areas to be worked across the 9 provinces. Tender 4 will focus on wetlands and dryland rehabilitation projects. Tender 5 is on operational research because part of the portfolio within the environmental programs portfolio, we do look at what sources of evidence or forms of research we should and can invest in to make sure that as a program, we are able to advance in terms of evidence-based decision-making and also towards continuous improvement in terms of how we approach our planning and implementation arrangements. We will still invest in terms of biological control research, which is a key aspect of our approach in terms of responding and addressing the management of invasive alien species. Because at this point, we focus on mechanical control of invasive alien plants. We also have chemical control, but biological control is also remains key in terms of us being able to sustain the operations in terms of not eradication, but minimizing and addressing the spread, the extent of the spread of invasive alien species. And there we have the mass rearing projects. And then the last one focuses on aquatic weeds removal, which is foliar and aerial herbicide sub-leader applications projects. And the process in terms of, in this regard, has been initiated, and as indicated earlier, we do intend to conclude this process by the end of the current financial year to enable us that from 1 April 2023, we'll be able to hit the ground running. And on that note, then, that is basically, my slide is not moving, but that was the last slide, Chair. Thank you very much.
Thank you so much, Ms. Mkizu, for the presentation. I want to get the members' hands. It will be Honorable Weber followed by Honorable Branch, in that order.
My apologies, Chair, struggling to unmute. Thank you very much for the presentation. And I really am happy to see that we do have this program. I specifically would like to focus a little bit more on the wetlands, as that is a natural resource that has been really neglected, and I know the department has been actively trying to rehabilitate and restore some of the wetlands. So my first question is just, how do you identify which wetlands will be done? And then it is a very specifically complicated restoration process, and that you will look on the criteria of what is needed. And then I want to know, if you appoint someone for 5 years, what has happened if after 2.5 years you realize these people really don't deliver? Will there be something worked into the contract if a non-performance that they can actually be growing? And then the second thing is this projects that you're talking about also responsible for the building of artificial wetlands where it's needed? And or is that a total topic on its own? One of the reasons of this questions is currently we had a problem with a mine which destroyed a natural wetland resources. Will that be a priority for this department or for this entity or program to go and assist to help with the rehabilitation of such a wetland when there was an accidental accident from a mine or illegal miners a destroyed environment. Thank you very much.
Thank you. Honorable Bright, over to you.
Thank you very much, Chairperson, and thank you for the presentation. I think we'd all agree that these bungles around the tender processes are something that can never happen again, certainly not under our watch as a portfolio committee. And I'm glad to see that the new tenders are already being advertised, and that there's also opportunity to take into consideration some new information that's coming through from the public hearings. So perhaps there's an opportunity there, a silver lining, to see if we can make these tenders even better this time around. I just want to ask quickly, first question is the presenter confident that no jobs have been lost or put at risk with the interim measure that's in place until January next year? I.e., would more jobs have been created if these tenders had been effectively put in place, or are we dealing with exactly the same numbers? And will they be looking at a different model in terms of the awarding of these tenders? One of the criticisms that come through has been that there's been too much centralization in terms of service providers, and that perhaps by devolving some of this responsibility, we would be able to ensure that that we have more certainty and security in terms of the awarding of these tenders. Thanks, Chair.
Thank you, Honorable Bright. Honorable Phillips, over to you.
Thank you so much, Chair. We have some load shedding, so my signal's not great. Thank you so much for the presentation. I really appreciate it. I just have some questions. I'd just like to know the contract that was extended to the that's referred to. How many provinces have aerial support, and where are the aeroplanes based? And then who's actually charged for those flying hours? Who pays for the use of that aeroplane once it's in the air? And then the amount of vehicles available specifically in the Rustenburg area, because what we find here is we've got teams for working on fire, but there's no vehicles to transport them. So we can't get them to, unless we go and pick them up, we can't actually get them to a fire, which is a bit of a problem. And then I just have a question on the non-responsive tenders. How many non-responsive tenders has the department had in 2021-22? And then how many contracts were extended by the department in 2021-22? Thank you.
Thank you, Honorable Phillips. Can the team respond to the issues as raised?
Thank you, Chair. It's Nanhlanhla Mkhize again. Let me put my video on. In terms of, I will start with Honorable Weber's question. I will let me highlight that I will be assisted by my colleagues, Mr. Ahmed Khan and also Mr. Michael Brack, in terms of the responses to the questions. I will start off with the Honorable Weber's question in terms of the appointment process of the service providers, whether there will be, what measures will be put in place to make sure that if within the 5-year period that there's poor delivery or not delivery at all in terms of the contracts. I would like to then assure the member and also assure the committee that when we appoint service providers, we enter into contracts with clear deliverables in terms of what is expected from the service providers. And as such, in instances where there is poor or not delivery at all, we have a process within the terms and conditions of the contract that we are able to follow. And also, if required, and if we do not find each other with a service provider, we will then have to terminate the contract. And we are very firm in that regard because we understand that when there are service providers that are not able to meet their contractual obligations in terms of delivery, it also affects our delivery as a department and also has implications, for example, on the APP of the department in terms of both the job creation, but also the environmental deliverables. The other question from Honorable Bryant in terms of whether the bid process, whether we're decentralizing at this point, the manner in which the tender was advertised or as was advertised on the 23rd, at that point it was not framed in a way that communicates a decentralized approach. We accept that it is not just accept, it is intended to be an open and competitive process. And the terms and conditions or the terms of reference are also drafted such that I mean, even though it does not necessarily address a decentralized approach, but it encourages and is clear in terms of possible subcontracting arrangements, because this is a portfolio of work that has to be applied and implemented across the 9 provinces. And also in response to, for example, the recent hearings on the Veld and Forest Fire Act, the public hearings, we've had to accommodate certain aspects on the terms and conditions or terms of reference that were advertised that were not necessarily in the previous tender. On the last matter, I would just request that maybe Honorable Phillips could repeat the question so that it's clear and we're then able to respond accordingly. But before that happens, Chair, I would like to, with your permission, just hand over to my colleague. I'll start with Mr. Bragg to handle the issues around the APWP job losses in terms of the numbers for the WAF program, and also for my colleague, Mr. Ahmed Khan, to look at just to expand on the process that we follow in terms of identifying which wetlands will be rehabilitated, because there is a process that looks at different layers of information in terms of how we then prioritize and make decisions in terms of funding investments. Thank you, Chair. Michael, please go ahead.
Thank you, DDG. Thank you, honourable members and honourable chairperson. In terms of the question, the number of jobs at risk by Honourable Bryant, the previous round of tenders were looking at 5,300 participants. The contracts that were signed for the period from the 1st of April until...
Whoever is speaking, we need to attach your face. We don't seem to have connectivity problems.
Is that better? Apologies.
Sure.
Apologies our network. So just in terms of the question in terms for Honourable Bryant, in terms of the jobs at risk, I was just saying that from the previous contract, from what was advertised previously and from what was advertised now, we've been constant in terms of the 5,300 participants forming part of the Working on Fire program. So we do not see the jobs being at risk in terms of changes. However, attrition rates have been quite high during this period of uncertainty, but those in the new contract will be dealt with in the 5-year period, so to try and reduce the attrition rates. In terms of Honourable Phillips's question, in terms of aerial support resources and vehicles availability, I would like to request that we can respond in writing, please, so that we can clearly articulate exactly where the aerial support are around the country and where the vehicles are around the country. Thank you.
Okay. Who's next? Did the Jim Kize who must respond to the issues?
Mr. Khan, Chair.
Thank you, DDG, and thank you, honourable members of the Portfolio Committee. Just with regard to the prioritization of wetlands, this has been informed through a number of, I think, consultative studies that's been done by Sandy. So the National Freshwater Priority layer is what informs where a lot of our wetland investments are being driven from. As you can imagine, there's significantly more wetlands degraded in the landscape than we have resources for. So we have to, I think, prioritize the way that we deal with the ones that have much more of an impact from a water resource management perspective. So you'll notice that a lot of our sort of priority layers are informed by the water source, strategic water source areas in the country. I think the question linked then to the artificial wetlands, no, that would not be a priority for us because we are primarily focused, I think, on restoring wetlands where there's a definitive link, I think, with the strategic water source areas that we could then impact from it. So that's just that particular perspective. I think another question around the tender models, I think that's also appreciated, and there are obviously, I think, processes underway to really unpack how potentially, I think, the market can engage a lot more, I think, actively and I think in a streamlined way with the ability to work for us. So the newest tender that the DDG referred to has identified all those areas in the landscape. We work on a compartment level. So you're talking about roughly a 30-hectare parcel of land that anybody then would be able to kind of interrogate and tender for in the tender that's going out. And of course, I think ideally you'd like as much sort of local players in that area to be able to bid for that work. And so all of those opportunities are there for whoever wants to bid and has the necessary, I think, skills and experience to do so, to be engaged with that tender. I think those are the two that I am at least. I think one of the questions was around the number of contracts that's been extended. The DDG mentioned there was a single source approval. So we had 24 of those contracts that featured under the single source approval to just keep projects going that ended, but for a period for this financial year to keep the continuity of employment and delivery going. And a further 35 that were extended with budget variations until the end of this financial year as well, because their contracts were sort of ending during the course of this financial year. That's as much as I can respond to now. Thank you so much.
That's all, DDG Mkhize?
Yes, Chair. That is all. The colleague has also responded.
Honorable Phillips will have to rephrase their questions. But what she did, the president doesn't say any. Oh, are you there? You seem to be able to solve the problem. Yeah, last time you were not audible enough.
I'm sorry. I don't know which question it was because my signal is very bad. Which question is it that they would like me to repeat?
DDG Mkhize? Which one?
Thank you, Chair. It was the question on the non-responsive tenders, which my colleague, it was me who missed it, but my colleague, Mr. Khan, has also then responded to it, specifying the number of contracts that were extended in line with the question that was raised.
Okay, thank you so much. Then I've got the answer. Thank you so much, Chair, and thank you for the answer.
Okay, can I then raise my issues as well? In all the provinces, Deputy Minister, where as the committee we have been, communities have been singing praises of the conservation and ranger program that the department or your provincial counterparts once implemented in many communities during the pre-democracy era to combat forests and field fire, pollution, poaching, invasive species, and other environmental problems. The communities want the program to be reinstated because whatever that replaced those programs, it's failing, dear. At some point, the committee will need to be briefed about how the old program operated and why the replacement program is not living up to the standard and expectation that was set by the old programs. And then the other issue that came critically during the recent public hearing, the on the National Field and Forest Fire Amendment Bill, it emerged that the operation of the working on fire are poorly managed and there's a lack of communication between fire protection associations on their plan. Sometimes the working on fire withdraws and redeploys its personnel abroad without consideration of the local fire risk or agreement with the umbrella association or the fire protection association. Then the issue that one wants to get clarity as you work on this, are there any working relations between the fire protection association and the working on fire programs, including planning and cooperation? And then one of the repeat proposal had been the transfer of the working on fire functions and budgets to the Fire Protection Association or their umbrella bodies. The thinking is that the impact on fire management will be enhanced if the personnel from working on fire and the Fire Protection Association were combined. Has this proposal been presented to the department, and what has been the position? And then having also read the presentation from the department, I don't think you have given us some information in the sense that one is meant to understand when going through the media that there is some litigations that are taking place. Without getting into the merits, can you assure the committee, maybe share with us what is making it then it becomes a litigious environment? And then the other assurance that one wants to get, it's whether this deadline that you are putting, that you are going to meet it. Are you going to complete this by the 30th of November as we put in the presentation? That's the issue. So that's why we're saying at the end, you got an extension from National Treasury. It's not going to become perpetual extension. And then the issue that is in place now, you said to me there's some legal review that is taking place. What is it going to have an impact on this? Are you still on course that come the 30th of November, there's going to be this matter concluded, knowing how our courts deal with these matters? That's why I'm saying, maybe if you can share with us in confidence without getting into the merits, then it will be very good. And then going through slide 10, DM, this department is deemed as a game changer in fighting poverty, unemployment, and inequality. And then there is this thing to say all the bids were deemed unresponsive. Maybe take us in confidence to say what's happening here, what makes these things not to happen, because honestly, wherein we've got this a lot of unemployment, poverty, inequality, and then there's been no response. Maybe take us through so that we understand what is this. So basically, those are the issues that one want to get clarity on. Thank you so much. Back to the team.
Chairperson, thank you very much, and thanks to the question. I think DDG Mkhize and DG Nomfundo Chabalala, some of the issues that you have just highlighted on are issues that we discussed before this meeting, for in case these questions then get to be raised by members. I will ask DDG Mkhize to respond to some and DG, and then if this is the last presentation, unless there is another one, and then I will then sum up. Thank you very much, Chair. DDG Mkhize? Through your Chair.
Thank you, Chair, and thank you, DM. Again, I will also share the responses with my colleagues in terms of the detail. I will request that in terms of the question, the Chair's question on litigation, that my colleague Vanessa Blenderman responds to that. In terms of the question in terms of with regard to I think it was the first question on the Ranger program. I think this is a matter that is then noted, and I would request my colleague from Forestry to expand, but I think this may need, Chair, with your permission, it may need for us to just do some further work so that we understand in terms of what the issues are. So as you highlighted that the communities want the programs reinstated, and the manner in which it was shared, it includes the scope of programs within the natural resources management portfolio, but it expands to other branches as well. On the issue in terms of how...
You might have not heard my question on that one. I'm saying at some point, you need to come and brief the committee about how the old programs operated, which the community said they were very useful and beneficial, and why the replacement programs is not living up to the standard and expectation that was set by the old programs.
Chairperson, can
Yes, DM.
I hear your question now. I think DDG is proper to follow the question of Chairperson of saying that at some time you must come to the portfolio committee and explain, you know, what project is that one. I think it's this is the project that we had then to terminate as a result of Auditor General with regard to where it was placed. Actually, it is BNC, if I remember very well. So I think we rather not respond on that one, because you have already said that it's forestry and it's not forestry. Therefore, let us rather than prepare a proper presentation, then we can come and explain to the chairperson and the committee, and also come up with a progress report with regard to that. I think that's the only way that we can do it. Thank you, Chairperson, if it's fine by you.
Thank you, DM, for that intervention, because I could see the DDG didn't understand my question. Proceed, DDG.
Thank you, Chair, and apologies for my response. May I request that we start off with the litigation one for my colleague, Ms. Benderman, to just respond on the issue that is before the court on the litigation. And then I'll also request my colleague, Michael Brack, that for whom we've been working very closely with our forestry branch in terms of just reviewing the terms of reference and making sure that the terms of reference of the current tender or the new tender respond to the manner in which the department, through our forestry branch, is intending to then support the FPAs in that regard. With your permission, Chair.
It can be quiet. We're waiting.
DDG, not Dada. DDG, not Dada. Can you please respond to that question? The relationship between the FPAs and the working on fire programs. I think that's one of the questions that I had, and also what DDG Mkhize just alluded to. Can you then respond to that? Thank you, Chairperson.
Good afternoon, DM. Good afternoon, Chair, Honorable Chair, and Honorable members. In terms of the relationship between the FPAs and the Working on Fire program, what we've tried to do, because of the challenges or the complaints that we've received in the past in terms of the support that the FPAs are receiving, as DDG Mkhize has indicated, working together with the EP branch, but also with the development of the FPA support strategy, which then once which is outlining what kind of support can be provided to the FPAs, looking at different pillars. Pillars range from issues of governance, issues of capacity building, and making sure that they can in the future be able to manage the work that they do and are able to implement the Act accordingly. Then Chair, what was the other issue? I think I have responded.
Chair, if I may come in, it's in relation to FPA, of which Forestry has highlighted that as a department, we have recognized that we had not implemented a holistic support strategy for FPA. That is why in the new tender, we are then looking at a support across all FPAs as part of the new Working on Fire contracting tender. So basically, I think it's realizing the shortcomings in the past, where we would have heard that certain FPAs were not necessarily supported adequately and not having sufficient capacity, that then the new tender is beginning to address this issue on an ongoing basis. Chair, if I may come through also on the last point that you've highlighted, and I would really highlight to the committee that indeed, as a department, we are also very prioritizing the issue of employment creation. And the issues of tender, I think it's mainly them being non-responsive, is to avoid a situation whereby when you have terms of reference and you realize that the various bidders have not responded adequately to what you want, you then do not want to go into a risk of appointing bidders that are not necessarily going to provide you with the service that you require. But this also is calling for us as a department to be very clear in terms of our terms of reference, but also when we then call for briefing of tenders, once we've advertised, we then need to be quite clear and concise so that we are then able to get responses to those tenders that will then meet the requirements. But as it stands, if the bidders don't meet all the requirements of the terms of reference as stipulated, you can then not go ahead as a department because that is going to be deemed as irregular. So that is what has been the main issue as to why some of these tenders were then seen as non-responsive. I will therefore hand over to Ms. Banderman to deal with the issue of litigation as requested by the committee. Thank you, Chair.
Thank you very much, DG. Good afternoon to the chairperson, the honourable members, to the Deputy Minister, DG and colleagues. Honourable Chair, you're correct. We cannot delve into the merits of the application that is pending. I do believe that the Deputy Minister or the department should in confidence share some of the, in terms of the pending litigation. However, in terms of the litigation at the moment, the matter has been delayed by the applicant in terms of the amendments to their papers. In terms of the implications for the current tender, it will not delay the current tender process that is ongoing. That there is no interdict restraining the department from proceeding in the current tender. The review application that has been brought by the applicant is challenging the previous cancellation of the tender, which the department has opposed. And that matter is ongoing, Chair. And so I think in terms of the litigation, Chair, if there's any further information that the Portfolio Committee requires, I think we can share that in confidence with the Chair and the Portfolio Committee. Thank you, Honourable Chair. I hope I've adequately responded.
Before you go, do I hear you that there is no legal review currently, the way you are proceeding it? Do I hear that?
No, let me clarify, Chair. What I've indicated is there is a pending review application at the moment before the court. There is no interdict against the department that restricts us from proceeding in terms of the new tender that is under consideration, Chair. I hope that clarifies that.
So, okay. So you're saying the legal review can proceed, then this won't prohibit yourself from proceeding with the tender process?
That is correct, Chair.
But that's the tender that is being taken on review. Maybe lawyers will advise us there.
Yes. So, yes, it is on our councils are advising in the matter. It is challenging the previous cancellation. The new tender is proceeding, Chair, and we believe that the new tender process is legally defensible.
Okay. It's fine then.
Thank you, Chair.
I don't see any other hands. Does the colleague have hands to raise? Follow up, nothing. Yeah, it has been a long day. Then, yeah, we need to wrap up. Maybe I need to be taken into confidence to say this new tender, somebody has said it's going to increase new participants to 5,300, the new tender. How do we arrive to that? Because like I've indicated earlier, this is all about fighting poverty, inequality, and unemployment. And once you delay these things, we stand to risk to address these jobless issues that we are facing with. And then my question on the repeat proposal from the communities on the transfer of the working on fire function and the budget to FPA, it's not adequately responded to, because the question was very clear. For those who have been moving around with us, DG, they had this. And then we wanted to hear from you in particular, and maybe DG Mkhize, whether this has been presented to the department. And what is now your position, DG? I was putting you on the spot, you and the DG, to that effect. Because at some point as the committee, we need to report back to those communities because they raised this issue seriously. So basically that's what one wanted to understand as we wrap out. You know, when I'm raising the issue of job, it's through our experience. Yesterday we had a meeting with Sunby and Sun Parks. And then they report something on the presidential youth employment stimulus. But then at the same time, they're talking about the 2 months job, the countries where these young people are. That's why now on the issues of job, you hear me raising the issue, because we want to understand if it's 5,300 jobs sustainable, for how long, it assists us to then understand and do oversight. Yeah, the last bite, DG and team, then we can close this.
Thank you, Chair. I'm going to request the DDG and the team to provide the details in terms of the 5,300 jobs. But on this second part, in terms of the proposals that are coming through out of the public hearing, Chair, we as a department had not necessarily made a decision around that. We are yet to look into how best can then the Working on Fire program and FPAs work together in the interim, while then we look into what is the most feasible and effective delivery model moving into the future. And that will entail a lot of discussion and consultation before we take a decision as a department. So we are looking at the interim in terms of the tender that has been revised, but then further details and consultation around the effectiveness of FPAs, the support that's required, and if ever there is a need to then pull the two together moving into the future. So Chair, I'm not quite sure whether that satisfies you, but I think we believe that as a department, we really need to apply our minds comprehensively to this matter, given that it will change the current position greatly, and we may not want to bring about a lot of disruption, and therefore would want to consult properly and ensure that if there is some scope of effectiveness moving into the medium to long term, we then look into that and make a decision and implement in that way. Chair, let me ask the DDG to talk to the 5,300 jobs. These are EPWP jobs, which tend not to be long-term jobs. However, given the program that is continuous, we have seen a continuous creation of this number or this number, which is now being increased on an ongoing basis as we implement this program on a continuous rollout. So the DDG can provide the details around the sustainability in as far as these jobs are concerned. Thank you, Chair.
Okay. I hope we'll meet in November. Is there somebody who wants to raise something? So DDG Kize, proceed.
Thank you, Chair. I am proceeding on the 5,300 jobs that the program, in terms of Working on Fire, the intention is to appoint a service provider over a 5-year period. And as such, because of the technical nature of the scope of work of this program, and also ensuring from a risk perspective that there's continuity on capacity to respond in case there are Veld and forest fires, the appointment of EPW, the intention is that the appointment of EPWP participants will align accordingly in terms of the term of appointment of the service provider. That's the one issue. Yeah, I think the other issue in terms of the FPAs, the DG has responded to fully. Thank you, Chair.
Yeah. Anything to raise before we close this meeting?
Thank you very much, Chairperson, and thanks also to honorable MPs. Mine is just to say that we have taken note of all the issues and the concerns raised by members with regard to especially the two tenders, that is the tender on Working on Fire and the tender on the natural resource management. But the issue that was raised by Honorable Bryant with regard to the job losses, I just want to indicate that that's one area that we all focus on in the department, because we want to make sure that we don't lose any jobs when we have this challenge with regard to the extensions of these two tenders. The last issue that you raised, the one that DG and the DG responded on, I think the delays are caused because of the kind of model that we're looking at in order for us then to get a suitable service provider. That is with regard to the 5,300 youth employment or youth empowerment that we've spoken about. Otherwise, thank you very much, Chairperson. We'll prepare the report that we promised that we're going to prepare for you. That is with regard to your first question when it comes to the issues of the rangers and the conservation raised by members when we were on public hearings. Thank you very much, Chairperson, and thanks to the team.
Sincerely appreciated, DM. Yes, we will continue to engage on this matter. Yes, let me thank all of you colleagues. It has been a very long day since 8:30 up to now. And then you need to go to the house as well. Thank you so much. Thank you, team DFFE. Thank everyone. The meeting gets adjourned. Thank you so much.
Recording stopped.
Thank you, Chairperson.
Okay. Bye-bye.